Good morning, ladies and gentlemen.
Good morning.
Morning,
Your Honor.
Judge.
Morning, Judge.
Yeah, I don't see any weirdos on here so far.
Good morning, Judge King.
Good morning.
Good morning, Judge.
Wayne County Jail. Good morning. Good morning.
Yes, sir. I just got Mr. Clemens and Mr. Cummins for you this morning, sir.
Clemens, and who was the other person?
Clemens and Cummins.
Cummins, okay.
Nicole Christian should be zooming in from the 6th floor.
Okay.
Clemens is mine, Your Honor, and I would, if I can, get a breakout room with him. That would be good.
Okay. Who do you have there, Wayne County Jail?
For me, sir, is Mr. Cummins. That's the other one I have.
Cummins. I don't see Cummins on the side.
Cortez Cummins. It's supposed to be for a tether violation.
Oh, that's probably why. Okay. Okay, we're gonna have Cummins come back tomorrow, so we can contact the appropriate people.
No problem, Your Honor.
Whenever you can get Clemens from me, that'll be appreciated.
He's sitting in front of the camera now, sir.
Oh, that's Clemens. Okay, we're ready.
Good morning, Your Honor.
Good morning, sir. Oh,
Case number 2305-64920, Police Michigan versus Danielle Clemens. Defendant is charged in count 1, assault with intent to get bodily harm, less than or by strangulation. Count 2, domestic violence. Second, offense notice. Domestic violence and wrongly assaulting a pregnant individual. Second, offense notice.
For the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Attorney Andrea Fanning, P 42853, appearing with Mr. Clemens. Mr. Clemens, can you state your name for the record?
My name is Darnell Clemens.
Thank you.
What's your pleasure, counsel?
Your Honor, I want to set this matter for exam, and if at all possible, I need a breakout room after we're done.
I was May 5th at 10 o'clock.
Your Honor, can we make that a little later? I have another matter on that day. Can we make it 11 or 12?
11:30.
That's great. Thank you.
May 5th at 11:30. Bond will be continued.
Your Honor, can I get a referral on the issue of bond?
Yeah, I'll refer.
Thank you.
I haven't had a chance to talk to my attorney before the course.
Right, he's putting us in a breakout room now.
Okay, thank you.
Thank you.
Join. Mr. Chris, good morning. David Cripps, are you there? David Cripps going once. David Cripps.
I'm here,
going
Your
twice.
Honor. I'm here. I'm here.
Morning. You're here on Martin. Are you ready on Martin, Mr. Cripps? Ms. Silver, what's going on
And
with your boss?
especially sign prosecutor.
He said he doesn't see the assigned prosecutor, Sir Judge.
I'm on.
Oh,
Here.
he's on, Judge. I think they're all ready.
As is
Mr. Cripps, the
co-counsel.
judge is looking for you.
I'm here. I'm here and ready.
Attorney Nelson.
Great.
There is a co-defendant on the case.
I'm
Who's
here.
Yeah, I saw Ms. Michelle on earlier.
We're all here then.
that? Great.
Call it case number 2305-6117. People of the state of Michigan versus defendant number 1, Demarion Hargrove, and defendant number 2, Charlie Martin. Both defendants are charged in count 1, homicide, murder, second degree. Both defendants are charged in count 2, weapons, felony firearm. Both defendants are charged in count 3, assault with a dangerous weapon. Both defendants are charged in counts 4, weapon, felony firearm.
Appearances for the record, please.
Good morning, and may it please this honorable court, APA Jonathan Hitz appearing on behalf of the people, P85288.
And good morning, Your Honor. May it please the court. Kim Michon, Neighborhood Defender Services, P59167, on behalf of Mr. Hargrove, who's in the Wayne County Jail. We would waive his appearance for these purposes.
Hey, good morning, Your Honor. David Cripps, P34972, appearing on behalf of Mr. Charlie Martin. I also would waive his appearance for today. He's in the Wayne County Jail.
All right, the court will waive the defendant's presence. What's your pleasure, counsel?
Judge, I did receive a link to discovery. That link was corrupted. Prosecution has sent another link, and I've also brought my external hard drive in just in case. And so I'm going to be in the building with Mr. Hitz. I figured we could probably get discovery today. Apparently it is quite large, which is one of the issues. So we're prepared to set a preliminary examination, but I start a trial next week.
Yeah, just for the record, Judge, because Ms. Michon and Mr. Cripps don't know this, I did receive an additional tranche of discovery from the Detroit Police Department. It is quite large. So that's going to add to the already voluminous discovery in the case. It consists largely of body-worn camera footage, dash camera footage, in-car video, and then several interviews conducted by the Detroit Police Department of the defendants and relevant suspects, or I'm sorry, witnesses. I am working to get all that uploaded and shared. I'm pretty close. I think I'll have another link out later today, or as Ms. Michon mentioned, I'm happy to meet up with either her or Mr. Cripps and provide it all via physical transfer.
Especially the additional suspects. I'm interested in that one.
I didn't mean additional suspects. Too early.
Is May 4th too soon? A week from today?
I have a jury trial scheduled for that day, Judge.
May 9th?
Judge, I'm starting a 2-week trial on May 9th.
Mr. Michon, when does your trial start?
Starts on the 4th, Judge.
In light of what I'm hearing, May 2nd is way too soon.
I would think so, Judge. I'm good, but I will leave walking on water to the Son of God. Too much discovery. Would the 26th work? I have nothing scheduled that day.
It's May.
26th is a Friday. My homicide days are Tuesdays and Thursdays.
I'm open either the 23rd or the 25th, if that works for Ms. Michon and Mr. Krebs.
It does not. I have final conferences with motions scheduled on both of those days.
All day?
Well, they're scheduled for, let's see, on the 23rd in the morning. And then on the 25th, I have motions in the afternoon.
So why not the 23rd in the afternoon, 23rd at 1:30?
That'd work.
I have a jury trial starting the day before, but I'm 90% sure I'm gonna settle that case, so I'll take a chance.
You
The
rebel.
It's all guesswork, you know that.
May 23rd at 1:30, bond will be continued.
Thank you so much, Judge. A lovely day to you and your staff.
Judge, could you refer to the bond?
Can I do what?
I think he asked for a DSU referral, Judge.
I would concur, Judge. If you'd order a DSU for both gentlemen, we would appreciate it.
Excuse me, Your Honor, as it relates to my client, I went to the breakout room, but they did not go to the breakout room. For Division 1, 8th floor, I need the breakout room, please.
Showed on my device that it went.
Okay,
I'll try it again.
I appreciate it. Thank you so much. I'm gonna try again. Thank you.
Okay. Ms. Silver. Ms. Silver, are you there? Ms. Silver going once, going twice. Mr. Murad. Mr. Murad, are you there? Mr. Murad going once, going twice. Moving on. Ms. Nelson. Good morning, Ms. Nelson.
Morning.
How can I help you?
I was ordered to appear this morning on a matter that's in front of Judge Jefferson.
In front of Judge who?
Jefferson, Jaquila Williams. I received an email from your clerk.
Moving on. I'm Judge King.
I know, I got an email from your clerk saying I needed to appear for Jaquila Williams. It is currently in front of Judge Jefferson, but there seemed to be some belief that it should be in front of you instead.
And Your Honor, if I may, I was notified by one of the prosecutors in Judge Jefferson's courtroom that there was a DV case that was set for PCC in that courtroom, and they wanted to verify that it was in fact a DV case, and it's a boyfriend-girlfriend relationship. So it did in fact confirm that, and it was my understanding that they were going to let the courtroom know in Judge Jefferson's courtroom that this case needed to be transferred to your courtroom. However, for some reason that did not happen and they just set an exam date. I did let Ms. Reynolds know this because that's a DV, that's a DV case and it should be in this courtroom. So I was hoping this case could be transferred to this courtroom.
Okay,
Yes.
calling case number 2206-03-7401. People of the state of Michigan versus Jacayla Williams. Defendant is charged in count 1, assault with a dangerous weapon. Count 2, police officer assaulting, resisting, obstructing. Count 3, malicious destruction of personal property, less than $200,000.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Sophia Nelson of Neighborhood Defender Service on behalf of Ms. Williams, P 77960.
All right. What's your pleasure?
This matter is currently set for an exam on April or May 2nd in front of Judge Jefferson.
It's not Judge Jefferson's case anymore.
Well, then I would ask for a new exam date.
You ready to proceed? Ready to proceed to exam on the council?
Yes.
May 3rd at 10:15.
Okay.
That's a good date and time.
Yes, Your Honor.
We continue.
Thank you very much. I appreciate it. Thank you.
Ms. Silver, are you back?
Yeah, sorry. I had to come into the building.
Okay, who do you have?
I have a PCC up this morning on a David Jackson. I just got retained yesterday. I haven't filed an appearance yet. I believe there's a co-defendant represented by Mr. Tuttles.
I don't see.
Oh, you know
Jackson.
what? Oh my God. I'm in the wrong place. Bye. Now I'm gonna get yelled at by Judge Jefferson. Will you call her and tell her I was timely? Bye.
Ms. Tiefo. Rebecca
Yes,
Tiefo?
good morning, Your Honor.
Good morning, Ms. Tiefo. You're here on Christian?
Yes, that's correct.
All right.
Is my client logged in, Your Honor? I've not had any contact, unfortunately.
Nicole Christian? Ma'am, in the Wayne County Jail, what's your name? I can't hear you.
Okay.
Nicole Christian?
Yes.
Okay, there she is. Who's her co-defendant?
Calling case number 2305-6489. People of the state of Michigan versus defendant number 2. Nicole Christian is charged in count 2, accessory after the fact to a felony.
Appearances for the record, please.
Good morning, Your Honor. Tina Ripley on behalf of the people, P83688. I'm standing in for attorney of record John Bella.
Good morning, Rebecca Chiappo, P62311, on behalf of Nicole Christian, who is appearing via the Wayne County Jail on Zoom.
Ms. Christian, tell me your name for the record.
Nicole Christian.
All right, so I understand that Ms. Christian has a co-defendant who has a PCC set for May 2nd.
That's correct, Judge. Mr. Bella would just ask if the court would adjourn this PCC to May 2nd to keep the co-defendants together.
Sounds reasonable. I'll adjourn it to May 2nd at 8:30.
Thank you, Judge.
I'm sorry, that's a PCC, correct?
Correct.
Your Honor, may I request a GSU report?
I'll refer to pretrial services for final recommendation.
Thank you, Judge.
Thank you. Mr. Woodyard.
Judge, good morning to you. I'm here with APA Lockbeeler, and I'm appearing on behalf of my client, Jermaine Fields. He is in custody, and if it's okay with the court, I'd like to wait until he's able to be present on Zoom.
Okay. We'll wait.
Thank you.
Who is this with the phone number ending in 9533?
Marcel Myrick.
Martell what?
Myrick.
Martell Myrick?
Yes, I was in there yesterday. I know my case got dismissed, but I know on my paper that I got here, it said I had a court date today too. I was just making sure.
Your case is dismissed, sir.
All right, thank you. Thank you.
Your Honor, if we can recall my case, I'd like to address the issue of bond. I know Ms. Drain is still here.
Recalling 23056492201 versus Darnell Clemens.
Again, for the record, Attorney Andrea Fanning, P42853.
And Shelley Drain for the people, P number 60249.
Thank you, Your Honor. We have already set a preliminary exam for May 5th at 11:30. However, currently my client's bond is set at $25,000, 10%. I'm asking the court to consider reducing that bond even further to a personal bond. It's my understanding, and if you recall, Your Honor, I was here yesterday because I thought this matter was scheduled for yesterday. He does have other misdemeanor matters, I think, pending before you, for which you have already given him a personal bond. I would indicate that
he wouldn't have a misdemeanor before me. I don't
yes,
do misdemeanor.
right. He has two pending misdemeanors before you, for which you have given him a personal.
He must have some things attached to him.
Okay. Nevertheless, I'm asking the court to consider a personal bond in this matter. He has been gainfully employed at UAW4 for over 10 years. He has no previous criminal history. He is a high school graduate. He has 2 minor children. I'm asking that you consider reducing this to a personal bond with a GPS tether. Again, I understand the severity of the charges. However, even when I score the guidelines on the assault with intent to do great bodily harm, less than a murder, it's a possibility they could be probationable. And because of this matter, he's not been able to go to work, and I'm trying to keep him employed. So for those reasons, Your Honor, I'm asking that you consider a reduction in bond.
Mr. Clemens.
Yes, sir.
What local? What local are you with?
I'm in local 600, the strongest local in the United States of America.
I see. Where do you work in local 600?
I work at a UAW Ford Motor Company, Dearborn Truck Plant, home of the F-150 plant on Rotunda and Miller, sir.
How long have you been there?
I've been, I started in 2012. I got hired in 2013. So it's been 10 years as of March of this year.
Who's your chairman?
My chairman is Nick Costales.
I know Nick very well.
Oh, you do?
I do. I'm local 600 as well.
Okay, good. Good to hear that, brother. Good to hear that, brother. That's why I'm with local 600. Yes, sir. Bernie Wrinkle is the president.
That's right. You know Stanley King?
Yeah, I've met him a few times. I don't know him personally, but I have met him.
That's my father.
That's your father?
Yes, sir.
Oh my God. Okay.
Yeah,
He's a good person from wherever I've spoke to. He's very spoke highly of your father.
Ms. Graham?
She muted.
Your Honor, I would only indicate that he does have one prior, and that is a domestic violence prior, because he was charged as a second offense notice. I don't believe he has any prior felony convictions. However, if he does have also pending misdemeanor cases, I would just ask that the court take that into consideration.
What are the misdemeanor cases that are pending?
It's my understanding from speaking with my client is domestic violence that was scheduled for yesterday. If I'm not mistaken, am I correct, sir?
Yes, I did go to court yesterday.
And those matters are scheduled for trial, if I'm not mistaken, May 17th.
May 17th. Yes, ma'am.
Same complainant?
Yes, sir.
And the parties do not reside together. They do have 2 children in common, but they do not reside together.
Ms. Graham, would you be opposed to a personal bond with the tether, no contact with the complaining witness?
Could I just ask if he was on a tether before April 16th?
Have you been on a tether before, sir?
It was several years ago when I was on the tether. I never violated anything like that or nothing. I met all the needs of the tether and got off, and I was done with it.
Okay, and so based on that, I would gather that he was not on tether for the misdemeanor cases that he is now.
No, ma'am.
Okay, so at this point, then I would not object to personal bond with a tether with no contact with the complainant.
All right, the court's going to reduce the bond to $25,000 personal with the GPS tether, no contact with the complaining witness. Don't make me be mean to a fellow 600 member, sir.
Yeah, Judge King, when I get back, I would definitely, I appreciate you. I got to get back and save my job, but I definitely would. I appreciate you. Thank you so much, sir.
Thank you, Your Honor. Thank you so much. And we'll be in touch, Mr. Clemens. When you get out, you can, I'll give you a call.
Okay, I definitely. Thank you.
Thank you so much. Have a
Judge
wonderful
King,
day,
you
everyone.
have a blessed day, Judge King.
Thank you, you too. Personal attack. Mr. Woodyard.
Judge, I was going to ask, when the gentleman from the jail mentioned who they had available, I did not hear Mr. Fields' name. Could you check with them and make sure that he's in the queue?
Mr. Clemens, can you get the deputy for me?
Yes, he's coming right now. He just got off the phone. He wants to speak to you.
Yes, Your Honor.
Hey, deputy, do you have a Jermaine Fields?
Hold on one second.
Your Honor,
Yes.
he's probably still in forensics.
Huh?
He's probably still in forensics.
Excuse me, Your Honor. Mr. Fields should be zooming in with you from Division 2.
Okay.
Yeah, they got Mr. Staples, Fields, Martin, Hartgrove, and Demetrius Johnson to be zooming in from Division 2.
Okay. Yes. You haven't been letting anybody out, huh?
You, sir. You and your staff have a good one.
Okay, thank you. You too. Mr. Raj.
Good morning, Judge King.
I didn't realize that was you.
Oh, it's okay.
What can
I
I do
was
for you?
saying, yeah. So I appointed to appear on Christian Nicole's case today. She was set for PCC this morning at 8:30 in your courtroom.
So Christian, you
Yes.
said you were appointed because Ms. Tiefo came in and she may have been retained.
Okay, that's fine. I just needed to know that she had retained an attorney.
Yes, Ms. Tiefo.
Okay, thank you, Judge. I appreciate you.
Okay.
Bye-bye.
Morning, Ms. Pilkowitz.
Morning, Judge. Was your clerk trying to call me? I apologize. On Staples?
Yes, you do have Staples up.
Yeah, I'm ready. I'm sorry. I was in a couple other courtrooms.
Okay.
Case number 2305-651701, Michigan versus Jamal Staples. Defendant is charged in count 1, unlawful imprisonment. Count 2, assault with intent to do great bodily harm, less than murder or by strangulation. Count 3, domestic violence. Defendant has a habitual offender. Third offense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Judge. Neighborhood Defender Service by Jackie Pilkowitz, P81653, on behalf of Mr. Staples, who is in the Wayne County Jail. I'd ask that the court waive his presence for purposes of this proceeding.
Or waive the defendant's presence. What's your pleasure?
Your Honor, I'm asking for the earliest possible exam date in this case. I have spoken with the complaining witness. She indicated to me that she does not want to pursue charges. She actually indicated she wrote a letter to the court. I don't know if the court is in receipt of anything. All of that to say is I anticipate this may be a dismissal. So, and because Mr. Staples is in custody, I'd ask for an early exam date.
Oh, yeah, he did write a letter, but I'm not going to read it.
Oh, Your Honor, I apologize. Is that from the complainant or my client?
It doesn't matter. I'm not reading from either party.
Understood. I just want to make sure my client, if you're not reading it, I guess it's a moot point, but it was my understanding that she wrote a letter.
We could do May 3rd at 11 o'clock. I can't hear you.
I can do that, Judge. Can we do it either May 1st or May 2nd?
May 3rd at 11 o'clock.
Okay, I'll make it work.
We continue.
Thank you.
And Shelley?
Yes.
Did you have any, we were corresponding. I apologize, Judge. Could you put us in a breakout room? Or I can do it on an open court. It doesn't matter. We were corresponding back and forth about Stanford. I don't know if we have an update. Would you have any objection to removing the tether in light of the fact that you can't reach the complainant? Or is there anything we can do other than him sitting in the jail until Monday?
Hold on 1 minute. Just trying to get to that case. Yeah, so I still haven't heard back from her, and I specifically asked her if she was staying, the message was if she was staying at that Losser address. I mean, I was able to leave a message, so, and I didn't get a call back. And the information that you have is that she does not live there anymore?
Correct, it's his place. It's just where the incident is alleged to have occurred, but she does not live there.
Okay, then I would have no objection to that.
Okay, so as in just
to what you have proposed
initially. So you want to keep the tether on, but we can remove the no contact provision from the Losser address.
Yes,
okay.
So that he can return there.
Yes, Judge, can I prepare an order and send it to the court?
You sure can.
Okay, thank you.
Okay,
that's all I've got. Thanks.
Trooper Michael Kane.
Yes, Your Honor.
Good morning, sir. How can I help?
I'm here on a Satirak Kolichi.
Sounds like you're in the wrong courtroom. Are you here on a traffic matter?
Yeah, this was where my subpoena was for.
Must have been an old subpoena. I'm guessing that you need to be in courtroom 435. So the Zoom number will be 360-435-0000.
All right, thank you.
Oh, he has. Yeah. So take those up, paste them. Hey, you talking to me? I'm talking to you. Oh, that's her. I see you in honor. You say, hey. Hey, how y'all doing today? Hey, what's going on? How you doing? Good. What you doing now? Case. So it's got flats. I got So I know people. That's right. Make me guess today, like. Oh. Yeah, it was fast. Oh. Just. So I would need to. Wait. Everybody else? Yeah. Here.
Nothing's ready yet.
Okay.
Yes, I know. No strings. Yeah, we'll check. Do I research?
Okay, have you seen anybody in Kenneth's house?
No. There's also I've been here all day with you, Your Honor. Ms. Taylor Pullman called me this morning and said that she was gonna log on at 10. I assume with other defense attorney regarding the 231, her father is in a bad spot, so she's gonna be asking for a continuance. I said I was gonna be here at 10, so we could zoom in and deal with that at that point. That's for Christian Malone, Christian Bell. You too. What's your name, sir?
Jermaine Fields.
Hey, Mr. Fields is here.
Judge, I'm ready whenever the court and Mr. Lockbeeler are.
Yes.
Calling case number 2305-5401, people of the state of Michigan versus Jermaine Fields. Defendant is charged with count 1, homicide, murder, first degree premeditated, count 2, weapons, firearm, possession by felon, counts 3 and 4, weapons, felon, firearm. Defendant has a habitual offender or defense notice.
Appearances for the record, please.
Good morning, Your Honor. Steve Lockbeeler for the people, P70668.
And Judge, good morning to you and to your staff. Michael Woodyard, my P number is 64612. I'm a staff attorney with Neighborhood Defender Service of Detroit, and we represent Mr. Fields. Mr. Fields, would you say your name out loud, please, and say good morning to the judge?
Jermaine Fields. Good morning.
What's your pleasure, Mr. Woodyard?
Judge, we are here for a scheduled competency hearing. I am in receipt, I believe the court is also as well, Mr. Lockbeeler is, I'm in receipt of a report that's dated April 24, 2023, and is authored by Ann, A-N-N, Zaborny, Z-A-B-O-R-N-E-Y, PhD. In this report, Dr. Zaborny has concluded that it is her opinion after interviews and testing that Mr. Fields indeed was competent and is competent to stand trial. Judge, I'll accept the opinion as something the court can rely upon to enter an order.
People, you stipulate to that as well?
Yes, Your Honor.
Okay, the court makes a finding that the defendant is competent to stand trial. What's your pleasure now, Mr. Woodyard?
Judge, we need to set this matter for a preliminary examination hearing, please.
How is May 4th at 11:30?
Judge, that first week of May is very problematic. I already have a couple of trials scheduled and an examination in your court.
You have an examination in my court?
I do. We're going to try and shoehorn it in on the 2nd in the middle of my trial. I'm available on the 9th if the court is. I know you do these exams on Tuesdays and Thursdays.
You do the 9th at 11 o'clock or 1:30? Sorry, 11:30. 11:30.
Judge, I would prefer the first opportunity after lunch. This may be somewhat lengthy.
1:30?
Yes, sir.
People, is that a good date and time for you? May 9th at 1:30?
Yes, Judge, that works for the people.
All right, May 9th at 1:30, bond will be continued.
Thank you.
Judge, thank you. Thank you. Mr. Fields, we'll talk. Okay, sir. Thank you, Judge.
Thank you. You're all set, Mr. Fields.
Is it also? You done?
Hey, Judge King, you done with Mr. Fields?
Yes, sir.
Okay, all right, thank y'all. Enjoy your
Thank you. Have a
weekend.
good day. You too.
You as
Be
well.
safe. Yeah. Good night. Yes, I will get it to you. Let me see that, 10 o'clock. They are. Yes, I will. Thank you so much. Anybody have a number? I do. We get it over there. Anybody wants to take it? 313-492-6333. He's parking and walking in now. Okay.
The news coming. So looks like our 2:30 is getting adjourned.
Yeah.
Oh.
I'm here disappointed.
I get disappointed in you guys.
Right.
I say it might be a disappointment for you guys.
Mr. Jackson wants to spend the day.
The news is coming.
Okay.
Can you try to call the number and tell them the just said so.
What's the number?
5, 4, 3. Turn the day.
You're supposed to be parking. Media's coming up too. So media's coming up too.
Absolutely.
Okay.
Judge on the bench here.
Yeah.
What's up, you okay? You'll leave the cuffs on? Yeah. Okay. Name and date of birth.
Jonathan Wood, Macy's, Montana.
Brought him up.
The older black guy.
Oh, Larry, what's up? How you doing? Yeah. Hello.
Mr. Gang.
Coleman Taylor is as well.
Good morning, Your Honor.
Good morning. What can I do for you?
I am requesting an adjournment of my exam today at 2:30.
Why is that?
I'm having issues with discovery and my father is non-responsive.
Sorry, I can't hear you. I heard issues with discovery.
And my father is non-responsive.
I'm so sorry to hear that. Okay, let me put it on the record, okay? Calling case 2356226. People of the state of Michigan versus defendant number 1, Tashawn Lawan McDowell, defendant number 2, Christian Antonio Malone. Both defendants are charged with count 1, homicide, murder, first degree premeditated. Both defendants are charged with count 2, assault with intent to murder. Defendant 2 is charged with count 3, felony firearm. Defendant 2 is charged with count 4, felony firearm. Appearances for the record.
Good morning, Your Honor, to staff, Brian Johnson, for the people of the 84143.
Good morning, Your Honor. Delisha Taylor Coleman, P56278, on behalf of Tayshawn McDowell.
Brian Gagnick, Your Honor, Neighborhood Defender Service, P64220. May I waive my client's presence for this matter? I am aware of what's going on.
You may. Ms. Coleman, you waiving your client's appearance as well?
Yes, please.
Okay, before we waive the defendant's presence, so Ms. Coleman indicates that she will be requesting an adjournment. She has a family emergency of sorts. That's the better excuse, more so than the discovery excuse, because that's not a good excuse when you wait to tell me about a discovery issue on the day of the exam. But you do have a legitimate excuse with the family emergency, so the court finds a good cause to adjourn the matter for that reason. Ms. Taylor Coleman, how much time do you think you're going to need?
At least 3 weeks.
3 weeks.
My family is in Seattle. It would be 10 days for all arrangements once he passes.
May 16th?
Your Honor, I'm scheduled to start a jury trial. Maybe just what's going to go.
Can we do the 10th?
I'm scheduled for a trial, but I don't know if that trial is going to go. I don't want to get stuck double booked.
Talking about the 10th of May?
Mm-hmm.
We have to do these on Tuesdays and Thursdays, so we have the 9th and the 11th of that week.
9th works better.
I can accept the 9th.
I believe I will be back.
That's not going to be pushing it for you because that's not exactly 3 weeks.
Yeah, that would be pushing it. Can we do the 23rd?
Going to be out of town that week.
I'll be out of town 18th through the 23rd. Actually, I'm sorry.
So you guys are gonna have to figure it out. I'm not going into June with this.
Can we do Fridays, Your Honor?
Sorry, Tuesdays and Thursdays are my homicide days.
Can you do the 25th?
I'm not gonna be in town. Yeah,
The 30th?
I'm not going to be in town.
I don't want to say the 9th, but I guess that's the only day available.
We do the 11th in the afternoon. Or late morning. I have to.
I can do the 11th in the afternoon.
How many witnesses do you have?
I have 4 witnesses.
I already have something scheduled on the 11th at 1:30.
What time?
I have something scheduled already at 1:30 on the 11th.
Would the court be able to do it at 2:30?
My exams, homicide exams, tend to last a little longer than an hour. We can try it. 2:30, May 11th.
Accepted.
Yes, sir.
All right.
May 11th, 2:30.
Okay, Bonner, be continued. Thank you. Prayers
Thank
to
you.
you, Mr. Coleman. Travel
Thank
safe,
you.
okay?
Thank you.
Oh, he's sick. He's wrong.
You walked in and you walked out. Let me go grab it.
Ready for him?
Yes.
Welch.
Calling case 2356044, people of the state of Michigan versus Jonathan Lamont, John Welch Jr. Defendant is charged in count 1 homicide, murder, first degree premeditated. Count 2 unlawful driving away motor vehicle. Count 3 fourth degree arson. Appearances for the record.
Good morning, Your Honor, your staff. This is Brian Johnson for People P8414.
Good morning, Your Honor. Jay Grant Miller, P58658, on behalf of Mr. Welch, who stands behind and to my left.
Tell me your name for the record, sir.
Jonathan Welch.
There's a date, time set for preliminary examination. Are we ready to proceed?
The people are mostly ready to proceed. The reason I say that is there is trouble finding one civilian witness. I have a witness detainer for him that I would present to the court. He is a necessary witness for the people. I have all the rest of my witnesses here, so I didn't know if the court wanted to hold it mostly in part, except for the one witness till we get him scheduled for another day, or adjourn the whole thing, which is.
So I don't know. Remember, if this witness is going to surface.
I can't speak to that. I can go get the OIC and I can testify to why.
How long have you been looking for this?
They've been, I can speak to Detective Williams. They've been looking, I can't speak to how long they've been looking.
Good morning, sir. Tell me your name, correct?
Douglas Williams.
Please raise your right hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. So, who is this witness that you're looking for?
Trayvon Wilkerson.
Trayvon Wilkerson.
How long have you been looking for Mr. Wilkerson?
For a week. He was shot. He was involved in a self-defense case. He was shot 4 times. For his mother and for our records.
Unrelated to this case?
Unrelated to this case. So his mom right now is passing me out because it's right down the street from where he lives. And she will not give me information where he is.
And I tried calling the mom 2 times. Both times they went to voicemail and I could not leave a message. The voicemail box was full. And I know that Detective Williams went out to the house at least one time and spoke to the mom directly.
So what's the plan going forward? Because we're going to hold this matter in part, but I can't keep this held out indefinitely.
Yes, sir. So what we're going to do is I'm going to go back out there and talk to the mom, and then I'm trying to have the marshals, our task force, get on and trying to find out where it is.
So, yes, civilian witnesses to that.
I have officers, at least he's the only civilian. And then at the end of the exam, the court signed the witness detainer.
I already signed.
No, I have one here.
Sure. Do you have any preliminary matters you'd like to begin with?
I do, Your Honor. I have 3 preliminary matters. The first one is the medical examiner's report that the people would seek to admit under 766.11B.
Any objection?
Not as to exam purposes only, Your Honor.
Admitted.
Thank you. And I'll publish to the court in just a moment. The second one is an MSP report, lab report, which will be submitted as Exhibit A under the same 766.11B exception to the rule.
Any objection?
Your Honor, if I get this, I can remove it. We'll stipulate to exam purposes only, Your Honor.
Admitted.
And then finally, also under 766.11B, Detroit Fire Department Fire Investigation Report that the people would seek to admit as Exhibit 6 under 766.
Any objection?
We've got no objections as to exam purposes only, Your Honor.
Admitted.
May I approach?
Okay.
The ME report is Exhibit 1. May the people publish?
Please.
Thank you. This is an ME report under ME case number 22-8300, performed by Dr. Jeffrey Hudson on Natalia Janice Morse, Natayllamorse. I've also provided a copy to the court reporter as well. The summary opinion is, it is my opinion that death was caused by blunt head trauma. Per investigation, the deceased was a 24-year-old black female who was found unresponsive in a field. Autopsy revealed multiple abrasions of the head, neck, and extremities, multiple abraded open skull fractures on the face, multiple near fractures of the bones of the skull and face, subgaleal hemorrhage, bilateral temporalis intramuscular hemorrhage, and he goes on, he talks about the injuries. The manner of death is classified as a homicide, so it's opinion that death was caused by blunt head trauma, and manner of death is classified as homicide. People will call their first witness, who is Cameron Brooks.
Your Honor.
Yeah.
Preliminarily, there is a defense motion for mutual sequestration of all witnesses with the exception of the officer in charge.
Ladies and gentlemen out there in YouTube land, if you are a witness or potential witness, I'm ordering you to log off at this time. There doesn't appear to be any other witnesses in the courtroom, aside from the officer in charge.
Gentleman in the mask.
This is our victim advocate, Your Honor. He will not be testifying.
That's fine. Thank you.
Sir, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Thank you, sir. Please have a seat to put the spots next to me. Speaking to the microphone is to your left, okay? Yes. Again, when you're ready.
Thank you, Your Honor. Can you please state and spell your name for the record, please?
Yes, sir. First name is Cameron, Cameron. Last name Burks, Burks.
And where do you work?
Through the city of Detroit, sir.
City of Detroit, Police Department?
Yes, sir.
Okay. How long have you worked there?
5.5 years.
Okay. What is your current rank?
I'm a police officer.
Okay. Patrol, normal patrol?
Yes, sir. Special operations.
Okay, thank you. I'm gonna take you back to June 4th, 2022. Around 12:45 PM, did you find yourself in the area of Canfield and Lenox?
Yes, I did.
And what city is that in?
City of Detroit,
And what county?
Wayne County.
And what did you observe when you got there?
When I got there, I observed a black female, approximately 25 to 30 years old, medium complected, wearing a bra, black leg pants, no shoes, laying deceased in the wood area.
Okay. And how far off the roadway was she?
Approximately 5 feet.
Okay. And you said she appeared deceased to you?
Yes, sir.
How could you tell?
She had blood around her face and head area. She was not moving.
And can you describe her face?
There was blood around her face.
Okay. And was she recognizable to you?
Not to me, no.
What did you do at the scene?
Immediately began to secure the scene, requested EMS to the location. Supervisor made the location.
Did you observe any evidence?
I did.
What did you observe?
I observed one stun shell casing in the street just north of where this individual was located, and there was a large cinder block like rock behind this individual's head, which had blood on it as well.
What did you do next?
I began to make my notifications. Therefore, homicide detectives would come out to the scene, notify the 5th precinct control desk, things of that nature.
Okay. Just normal investigation. Yes. Did you speak to anybody?
Yes, I did.
Okay. After you spoke to those people, did you have any other involvement in the scene?
I stood by.
Okay. Yes, sir. Okay. I have no further questions, Ms. Woods.
Cross-examine.
Officer Burks, can you hear me okay?
Yes, sir.
All right. I want to take you back to the June 4 date. You said you observed a shell casing in the road. How far was that from where you observed the body?
I don't recall the exact distance. It was a little distance away.
So from me to you, or possibly you to the officer back there?
I don't want to put a specific amount of feet on it, but it was fair to say that it was a little distance away.
I'm just trying to get an idea. I'm not trying to pin you down to any number here.
Maybe about 3 houses north of where the body was located.
Okay. Now, so the shell casing wasn't in front of the lot where the body was discovered?
No, sir.
Okay. Do you remember what kind of shell casing it was?
Not an answer. No.
Rifle, pistol, you don't remember?
Not that I recall.
Okay. Now, you said there was a cinder block located near the head of the decedent?
Yes, sir. It was not necessarily a cinder block, but a cinder block like rock.
Okay, so possibly a broken piece of cinder block or just a gray, possibly concrete type rock?
Potentially, yes.
Okay. How far away was that?
Directly right between this lady's head.
So within a foot or less?
Yes, sir.
Okay. Now, on that date and time, were you working with a partner or were you working alone?
I was working with a partner.
And who was that?
My partner that day was Quentin E.
Okay. And you guys, I don't know if the prosecutor asked this, so I apologize. Were you fully marked?
Semi-marked shot.
Semi-marked. Okay. And just out on regular routine patrol?
We received a police run for a dead person observed.
Okay. Was this an emergent run or just drive by the area and check it out?
It was pretty emergent. Some caller had said that there was a body located in the field.
Okay, so then, sorry, my next question. Did you run with lights and sirens to the location?
Yes, we did.
Oh. And were you the only car dispatched to the location at the time?
No, sir.
Okay. So call went out, more than one car was called to the location?
Yes, sir.
All right. No further questions, John?
Can you read? Hang on. Thank you, sir. You may start. Thank you.
Call Sergeant Dominica Maida.
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Please have a seat for the response. Give me your ready.
Thank you, Your Honor. Can you state and spell your name one more time for the record, please?
Dominica Maida, Domijada.
And where do you work?
Detroit Police Department,
How long?
about 7 years.
About 7 years. What's your current rank?
Sergeant.
You're a sergeant, okay. And what are your duties? What are you assigned to?
Right now, I'm assigned to the Detective Bureau that oversees all the investigative units.
Okay, were you a sergeant or a detective back on June 4th, 2022?
Yes, I was a sergeant assigned to homicide during that time.
Did you come to be involved in a case that occurred on June 4th, 2022 that occurred on Lenox Street?
Yes.
Is that in Detroit?
Yes.
City of Wayne, or County of Wayne? Did you go to the scene?
Yes.
And what was your involvement at the scene?
We got recalled to investigate the homicide, canvas, talk to witnesses, look through video.
Okay, were you able to find, during your investigation, did you speak with any witnesses?
Yes,
And during your, do you remember how many?
about 3.
And were you able to watch any video?
Yes.
And based on what you saw, what did you do next?
So in the video, I saw a white sedan car. So when we got back to the base, I looked up any vehicles that were either towed or burned that were white in color.
Why did you do that?
It is common that individuals that are involved in crime later dump their vehicles, either burn or abandon them. So I wanted to see if anyone towed a white vehicle.
Do you recall what kind of car you were looking for?
It was a white sedan, and I did come across a white Ford Focus.
Okay, what was the white Focus in relation to?
It ended up being burned, and it was registered to a female who matched the age of our victim.
Okay, and were you able to pull up this person? Do you remember, you call her name?
Natalia Morse?
Were you able to pull up this person's photo?
Yes, I pulled up her driver license picture.
Okay, and what did you do with that?
I compared it to the pictures the person I seen on scene.
Okay.
And the person I seen on scene had a tattoo on her chest that said Regina. And then the person in the Secretary of State picture also had a tattoo on her chest that said Regina.
Okay. So it was the tattoo. Were you able to, was her face recognizable?
Not totally, no.
So you were able to identify her through the tattoo?
Yeah, based on the Regina tattoo.
With the burned car, what else did you do? Okay. With the information, was it limited to just identifying the victim, or did you do anything else?
I passed that information along to my team, but I never responded to where the vehicle was found.
Okay.
Or actually looked at the physical vehicle.
Okay, so you just, you found a report of a burned vehicle?
Yes.
That possibly matched the, what you saw in the video?
Yes.
I have no further questions, Mr. Witness.
Cross-examine.
Sergeant, can you hear me okay?
Yeah.
Okay. So what was this video that you observed?
It was just a vehicle that was driving in the middle of the street that showed an individual getting out of the vehicle and running back to it.
Okay. And I apologize, maybe it was asked, but where was this video from?
It was from a cell phone video that a witness took to see.
Okay. And do you remember what the witness's name was?
I believe his last name was Wilkerson. I don't remember his first name.
Okay. But it was his video that you witnessed, not a door cam video or green light video or anything like that. It was a cell phone.
Correct.
Okay. Now, could you make out a license plate on the car? Could you look at the video? No. Could you tell if it was a Michigan license plate or foreign license plate?
Not that I recall.
Okay. And now when you're doing this search, what kind of search are you doing for towed or burned vehicle?
So in our records management system, RMS system, that's how we do our reports. There's a way to look in the last 24 hours of any reports filed of a burned or towed vehicle. So I just did a 24-hour search of any towed or burned vehicles that were reported in our system.
And were you looking for all types of vehicles? or
White sedan,
Just white sedans?
yes.
Okay. You weren't looking for any silver, gray sedans?
No.
Nothing further.
Can you redirect?
No, Your Honor.
Thank you. You may step down.
We'll call Reginald Weasley.
So please step forward, give your name and spelling to the court reporter. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Thank you, sir. Please have a seat for the response. You may begin when you're ready.
Thank you, Your Honor. Can you state and spell your name one more time for the record?
Reginald Beasley, Reginald, last name Beasley.
And where do you work?
Homicide.
Homicide's a big word. What?
Yeah, Detroit Police Department, homicide section.
And how long?
I've been with DPD for 19 years, been a homicide since about 2016.
And what is your current?
I'm currently a sergeant in charge of the Eastern Squad.
Okay. I'm gonna take you back to June 4th, 2022. Were you on duty that day?
Yes, sir.
Okay. And did you find yourself at 4677 Buckingham in Detroit?
Yes.
Okay, and why did you go there?
I went there to make a death notification on a homicide.
For who?
That's how you Morris.
Okay. Were you able to make that notification?
Yes, I was.
Okay. Do you know if it was her house?
Yes, it was.
And while you were there, what did you do? Did you do anything besides the death notification?
Well, I spoke to her aunt and another those that live upstairs where she stayed at, the two-family flat. They gave consent to go upstairs and search her bedroom.
Okay. Did you find anything in her bedroom?
Yeah, there was a tablet plugged in next to the bed.
What kind of tablet?
It was an iPad.
Okay. And did you collect it? Was it collected?
It was collected. I directed Officer Janon to collect it.
And what did you do with it after that? Or what was done with it?
It was placed on evidence and turned over to cellular evidence.
Did you have any other involvement in this case with the iPad? Any other involvement?
That was iPad, no.
Okay. What other involvement did you have?
Well, I was part of the investigation, did search warrants, just system investigation.
Did you go out to did you have anything to do with the Ford Focus?
Yes.
What did you do?
The Ford Focus was found burned. We discovered it was burned the day of the homicide. We found out it was burned at a location and impounded. We went to the impound lot and had the car towed to our evidence garage.
Did you do any investigation regarding the burned car? Like, did you do anything with the burned car as far as determining cause of?
No, no.
I have no further questions, Mr. Witness.
Cross-examine.
Thank you. I'm sorry, was it Officer, Sergeant?
Sergeant, sir.
Sergeant Beasley. You can hear me okay?
Yes, sir.
All right. I want to go back to this Buckingham address. Did you say it was a two-family flat?
Yes, it was upper and lower unit.
Okay. And do you know where Natalia lived?
According to the family, she resided upstairs. I did find a bedroom with her belongings.
Okay. Now, did you knock on the door for the upper unit to do the notification or the lower unit?
If I'm not mistaken, it was a common entry door. We made contact with the family in the lower unit and a relative. Her unit came downstairs and we spoke with them also.
Okay. So do you remember what relative you first spoke with?
Yes, Miss Connor.
Miss Connor?
Yes.
Okay. And do you know who that was, Natalia?
She identified herself as her aunt.
Okay. And I'm sorry, did you say then somebody came downstairs from the upper flat while you're talking to her?
Yes, Mr. Willis, I think that is Willis.
Okay. Now, when you're at the Buckingham address, did you have a search warrant in your possession?
No.
Okay. Do you remember who told you you could go into Natalia's room?
Yes, Mr. Willis.
Mr. Willis? And do you know his relation to Miss Morris?
I don't recall his relationship. He did say he was a relative.
Okay. When you went over to Miss Morris's location, did you have any information on her?
Besides her name?
Name, address, age, date of birth, anything like that?
Yes, I know where we're going. Yes.
Okay. Do you remember how old she was?
I did not recall.
Do you remember, was she over 18?
She was.
Okay. Nothing further to this witness, Your Honor. Thank
Can you
you.
redirect? No, Your Honor. Thank you, sir. You may step down. Any other witnesses for the people?
I have two witnesses, Your Honor. I have analyst Nathan Howell.
Sir, please step forward. Give your name and spelling to the court report.
Yes, sir. Howard, M-A-H-A-N-H-O-W.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. Please have a seat with this file. Thanks. Thank you. Get me ready.
Thank you, Your Honor. Can you state and spell your name one more time, please?
Yes, Nathan Howell, N-A-T-H-A-N-H-O-W-E.
Can you pull that microphone towards you a little bit?
Sorry, yeah, for sure. Is that better?
Yes. And where do you work?
Detroit Police Department.
And how long have you worked?
4 years, 10 months.
Okay. And what is your duty, or what is your occupation?
Currently I'm assigned to crime control strategies.
Okay, and what is that?
We help with the downtown detail for things like Greektown. I also investigate some patterns.
Are you a police officer or are you an analyst?
I'm a civilian crime analyst.
Okay. And what kind of education do you have?
I have a master's in science from Wayne State University in criminal justice and a bachelor's in sociology from LA College.
Okay. What is your what kind of training do you need to be a?
We attended a PIAT training, which is the Foundations in Analysis training. I've gone to a training in California for crime analysis as well, and additional trainings that EPA has done.
Okay. I'm going to take you back to June 10th, 2022. Did you analyze some records in
Yes.
relation to a homicide that happened in Lennox and Canfield?
Yes.
Okay. And what kind of records did you analyze?
I looked through Text Now, Pinger, and Spotlight by Total.
And how'd you get these records?
I believe one of the detectives did search warrants for each of these, then provided them to me for analysis.
Okay. So we'll take it one at a time. You said Text Now.
Yes.
What is Text Now?
It's a VoIP service, so it stands for Voice over Internet Protocol, and so it can be a second number you can have that you don't need wireless service, like you don't have to have AT&T. You just need to have a connection to Wi-Fi or carrier data, so 4G.
Okay. And can you use it on an iPad?
Yeah, if you have 4G carrier Wi-Fi, yeah.
Okay. So do you have to, is there a phone number associated with the VoIP? The voice over
Yes,
internet?
yeah, it will work. It will function as a secondary voice phone number.
But is it different than, say, a phone number you get from your carrier?
Yes.
Okay.
It's its own distinct phone.
Okay. So you said Text Now. What was the other one?
Pinger, P-I-N-G-E-R.
And what is Pinger?
It's also a VoIP service company that operates those apps where you get a second phone number.
Okay. And then we're talking about applications for a phone or for a tablet?
Yes.
Okay. So you would download it and you would be able to make phone calls or make video calls from that app?
Yes.
Okay. Are text now and Pinger similar in that regard?
Yeah, they probably same functionality.
Okay. With the Pinger stuff, what did you do?
I reviewed, text messages, in that, what they sent over from the server.
Okay. And what did you, when you reviewed them, what did you find?
I saw, 2 phone numbers, that had been texting, morning of the homicide about, doing a sexual transaction. And the 2 phone numbers were, 313-636-0697 and, 586.
Objection. I apologize for not standing up sooner. My basic objection is foundation. We haven't established how these information came into this officer's hands via some alleged search warrant. The people haven't laid the foundation for him to even start to testify as to what he may have looked at.
He could testify to what he looked at. I mean, I could bring in the officers that did the search warrant. I have the officer out
I
there.
don't think any of that is necessary. He testified that he received certain information from certain officers in charge. He's testifying as to what he did with that information, not necessarily as to its origin.
Yes, sir. Now he's also testifying to the substance of the messages by trying to recite phone numbers, which I don't believe the people have laid the proper foundation for those to be placed on the record either.
So you talked about this evidence.
Yes, Your Honor.
I can put them in. All right, I'll let you know. Okay. I approach the witness, Your Honor. Mr. Howell, I've handed you some papers. What have I handed you?
Looks like you handed me, records of the, 2 phone numbers that's not the site. Took a communicating and it looks like it's, contains, messages. Yeah.
Is that a document that you reviewed before?
Yes, yeah.
Okay, and where is it from? What are the contents of it from?
This looks like it's from Hanger, it looks like.
Okay. And is it a fair and accurate depiction of what you reviewed at the time?
Yes.
Okay. People would seek to admit People's Exhibit,
This is
People's Exhibit 4.
May inspect the.
Okay.
Let me ask just a couple questions, Your Honor.
Trying to be direct now.
No, I just want to ask the question, is this every possible communication from the time frame of the 6/4/5/13 going back to 6/2 at 20 hours, 47 minutes and 50 seconds?
It sounds like a cross-exam question. He's asking to admit this particular exhibit. Do you have any objection to it?
No, Your Honor.
Admit it?
Thank you, Your Honor. May I approach the copy for the court?
You may.
And Mr. Powell, may I approach the witness?
Yes.
We're approaching with People's Proposed Exhibit 7. What have I given you here?
This looks like simply the, Hanger messages as well, but it looks like it's only ones from, it's UTC time, so you have to subtract 4, so it's from 1:13 AM to, 12/19.
Do you recognize it?
Yeah,
Did you work with that document?
Yes, this is, this document work with.
Is it a document that you took information from and worked with the information that you had?
Yes,
Is it a fair and accurate depiction of what you worked with?
yes.
Okay. And there's some, well, all the people would seek to admit it was exhibit 7.
Any objection?
Yes, Your Honor. There appear to be photograph copies on the exhibit you were handed of sticky notes. Is that correct?
Yes.
Are those your sticky notes?
No, these are my sticky notes.
Your Honor said it, I'd object as to, we haven't laid the foundation for, I understand the pinger.
These sticky notes, Mr. President.
Who's, I can go into it. Whose sticky notes are?
I believe it's Detective, Detective, but all I see is face.
Detective
Well,
Williams?
Did you
sorry,
receive
yes.
those sticky notes along with that exhibit at the time?
No, at the time, these weren't on the exhibit when I originally reviewed the information. I
Do you
reviewed
have
it.
a clean copy without the sticky?
I do not have a clean copy of that sticky notes. I apologize. I thought. No. Which one is trying? Me? Yeah, trade. Okay, what have I shown you here?
The same document, absent the sticky notes.
Okay, it's a fair and accurate depiction of what you reviewed at the time,
Yes.
and it's highlighted. There's some highlighting on there. Did you make those highlights yourself?
I don't remember, no, I don't remember.
Okay. Did you review it with the highlights on it?
No, I don't believe I did, no.
Well, what did you do? What did the highlights represent?
Represents communication between the two numbers that I was gonna recite, 313-636-0697 and 586-842-2111.
So are they what you would, do the highlights just direct you to what you were going to talk about anyway?
Yes.
People seek to admit document as exhibit 7.
No objections for the limited purposes of exam.
Thank you. I have a copy. Is it okay if I give a copy of the sticky notes? Just, I won't.
I trust the
Will you
court to
ignore it?
ignore
Yeah,
the
will you
sticky
ignore the
notes,
sticky
Your
notes?
Honor.
Right? Okay, thank you. Well, actually, we'll do this. Right. Okay. So now we got 2 documents. Let's talk about them. Let's talk about Exhibit 4 first, which is the longer document. Okay, so these came from the Pinger app?
Yes.
Okay, and Brother Counsel asked a question, which I think is a fair question. The time, the very top one, where it's 6/4/2022 or 2022-0604, is that the last communication that you were able to get from the Pinger app?
Yes.
Okay, so is there any communication that occurred after that that you were able to get from the Pinger app?
No, I don't believe so.
Okay, so let's go to the last page. 06/02/2022. And there's some text messages there. Is that the first communication that you were able to receive with the Pinger app?
Yes.
Were there any other communications that you received from the Pinger app that you analyzed?
No.
Okay, so
You're referring to a document that says 0602.
so on the last, I'm looking at the date, Your Honor. I'm looking on the very last page. The text message at the very end says 2022-06-02. There's a text message.
Oh.
On the longer one. Yeah. Yeah. So everything that you have, everything you analyze, I should say, came from this document. Did it come from this document?
Yes, for the finger, everything came from this document I have here.
Okay, so let's talk about it. What did you do with the text message? Did you review any text messages between numbers here?
Yes, I did.
What numbers did you review?
I reviewed the 313-636-0697, as well as the messages with that number in 586-842-2111.
Okay, so looking at the very first text message, it says 586-842-2111. The recipient is 313-636-0697. Which one was the Pinger number associated?
That's the 586 number.
Okay, and do you know who that number belonged to?
Yes, I do.
Who?
Jonathan Lamont, John Welch Jr.
And how were you able to determine?
I had to look at messages between that phone number and another phone number, which is also in this document.
Okay, and we'll get a page. I'm on page 5. Can you tell me what number that you look at?
Yeah, it would be the 586-222-7539.
Okay, and what does that text message say?
Which page are you on again?
Page 5. Like halfway down.
There's one I see, places halfway down, it says D5S.
Okay, go a few above that.
I don't know what you're talking about, this phone.
What above that?
Oh, you don't understand how serious this is, Jonathan.
Okay. So with that information you had, the 582-842-2111 and named Jonathan, how did you, what investigations did you do to come up with the name Jonathan?
So first with the number at the end 2111, I use Clear.
What is Clear?
Clear is a legal investigative software solution. They use public records and proprietary records, provide law enforcement with information on individuals. Okay, and did you enter that number into Clear? Yes, I did. Okay, what did you come up with? It provided me with a record of Quail, with the address of 20648 Commercial Street, Parker Woods, Michigan. Okay, what did you do with that number, or with that information? With the information, I ran that address on Commercial Street, Parker Woods, into Lean, so I did an address search, which provides you with individuals registered to that address. And so I came up with an individual named Zalia Quail Frazier, giving me the individual Quail Clear, as well as an individual named John Welch Jr. registered to that address. Okay, and was it associated, like what were their names just out there, or was it associated with something? Like, how did you come up with those names? On the so Quail and Jonathan Lamont Welch. Quail was from Clear, and Clear also provided the phone number was associated with that Kenosha address. Why was it associated with the address? I guess that's a better question. How was it associated? Because Zalia Quail Frazier lives at was registered, I should say, at that Kenosha address on her driver's license. Gotcha. Okay. All right. And did you do anything with the name Jonathan Welch? Yes. What did you do? I searched RMS as well as Lean to bring up the driver's license and the driver's license photo of Mr. Welch.
Okay, did you find his address?
Yes, in Lean it's 20648 Kenneth Street, Harvard, Michigan.
Did you also, did you review public records for Mr. Welch?
Yes, I did. When I searched public records for him, I came up with in Clear. I searched his name as well to start with, and he came up as having another address associated with his name from February 10th, 2022 of 13,000 Gilman Street, Detroit, Michigan.
And how did you determine that that was his address?
So first and foremost, Clear stated that it was an address he had. I also checked the property records in Clear. You can search an address in Clear and it'll provide you with seller, buyer's information, property addresses. He was the property owner of that residence at the time. And then I also searched the Wayne County's tax assessor website, and he was the individual on file for responsible for paying the taxes for that address.
Okay. And when we're reviewing, when you're looking at these, we'll go back to the big document here, Exhibit 4. Did Kilbourne Street come up on that, on those documents?
Yes, it did.
In what capacity?
It was sent from the 2111 number to the 0697 number as the address to meet at.
Okay. And what address was given?
13010 Kilbourne Street.
Okay. Was that the exact address that was that you saw Jonathan Welch was owner of?
No.
Okay. What was his address again?
13,000 Kilbourne Street.
So 10 off 13,000.
I believe it's next door.
Okay.
I think.
Did you search 13,010 Kilbourne Street in the public records?
Yeah, I did.
And did you come up with anything, any investigation or anything that caught your attention?
No, not really. I couldn't connect it beyond the address being sent in the text messages to the homicide investigation. So,
Okay. Did you also review video?
yes.
And with this information that you got, did you review the video first or did you review the phone records?
We had the video first.
Okay, so let's talk about that. What video? What did you do to start reviewing the video? What was your first step?
So I worked backwards from the scene location of Langston Canfield.
Okay.
And started reviewing the Project Greenlight cameras we had in the area to trace back the white Ford Focus.
Okay. Were you able to locate a white Ford Focus?
I was.
And where were you able to trace it back to?
I traced it back to the Kilbourne Street area.
Okay. Were you able to put it at 13,000 Kilbourne?
No, I could place it turning onto the street. Is either when I reviewed the video from the cameras, it turn onto the street or onto Rosemary Street, but with the information, I guess now.
Okay. And so you, just so I'm clear, you worked from where the body was found, Lennox Canfield, and you traced a Ford Focus back to near Kilbourne Street?
Yes.
Do you recall what time it was, or do you recall what date that you not the date that you reviewed the video, but the date of the incident that you were looking at?
Yeah, it was June 4th.
Okay. And around what time?
I believe it started seeing it leaving Kilbourne around like 2:40 something. I think.
AM or PM?
AM, sorry.
And that leads me to another question that I just remembered. On the left-hand side of this document, Exhibit 4, it says message, content, date, time, UTC. So you had mentioned UTC earlier. Can you just briefly tell us what UTC is?
Yeah, it stands for Universal Time Code.
Okay.
And so in order to standardize it to Eastern Standard Time Zone, you subtract 4 hours from it.
Okay.
So 5 is really 1.
Okay, so these text messages where it says 0513, you always subtract 4 hours, so it's 1:13 a.m.
Yes.
Okay, is it military time, 24 hours? So if it was 1800, it would be really 1400, which is 2 o'clock.
Yes.
Yeah. I have no further questions for this witness.
Cross-exam.
Thank you, Your Honor. Mr. Howell, can you hear me okay?
Yes, sir.
Thank you. I can hear you wonderfully as well. I want to go back to, you were handed some information for TextNow and Pinger, is that correct?
Yes, I believe this is Pinger.
Okay. You didn't request those records yourself? You didn't obtain those records yourself?
No.
Okay. Do you have any idea if they're a complete record of the Pinger or TextNow account?
This looks like it's just one of the Excel files I reviewed.
Okay, so it may not contain all the information that would be on the Pinger or the TextNow?
No, it wouldn't.
Okay, so it's been edited down to possibly just looking for a couple of specific phone numbers?
This smaller one that had the sticky notes on it is, and then this one is the entire Excel file.
Okay.
It's 4, sorry.
So are there more than just the 2 phone numbers and longer document contained?
Yes, sir.
Okay, so multiple accounts going out to different numbers?
Yes, multiple messages.
Okay, but to different phone numbers, not the ones we were just discussing?
Yes.
All right. I'm sorry, I'm not as up on technology, so Mike have to walk me through this slowly. Now, you start taking a look at these documents that were handed to you, you don't know who requested them, do you?
I believe Emily James, officer, was one who did the search.
Okay. All right, but you get the documentation and it's the Excel file, the one's a complete file and the other one's a pared down file, is that safe to say?
Yes, that's safe to say.
Okay. Now, you then use Clear, is this a public program? Is it a subscription based? What is Clear?
It's a subscription based program, law enforcement pays for. And you can search individuals, phone numbers, businesses, addresses, information. And it consolidates it all for you into one record of returns.
Okay. Now, and that's what you were using to look up the 2111 number?
I used it to look up that number to determine like what carrier, if it had a name associated with the right.
Okay. That is where I was gonna go next. Do we know what carrier was associated with that phone?
That was Pinger. That's the Pinger number.
Okay, so that's just the Pinger, it didn't have any other cell service attached to it?
No, it just provides you with the voice.
Okay. So what about the 0697 number?
That one was just TextNow. Just came back with TextNow.
Okay, so no other phone carrier attached to that one either?
No, just same thing.
Okay. What about the 7539 number?
Oh, that is that was the Oil Fraser's number. That came back as T-Mobile.
Okay, so that one was a T-Mobile number.
I believe so, yeah.
Okay. And that was the one that came back as that Quayle.
Yes.
Okay. Sorry, I'm trying to piece the word together there. Now, she was somehow affiliated with the Kenosha address? This Quayle?
Yes.
Okay. Was she on the property taxes or anything?
No, I remember her seeing her in the property.
Okay. Then how was she linked back to the Kenosha address?
In clear, phone numbers will be linked to addresses. T-Mobile one, this one was, and it was linked back to that, Kenosha address. And then once I had that, since obviously Quayle isn't a real first last name, I searched that Kenosha address in me and saw someone named Talia Quayle Frazier and put together that one thing.
Okay. And now when you were using Clear again to keep searching this Kenosha address?
I use, well, Clear and Lean, but Lean, since it's the official records for people's driver's licenses, I use that one to search the address to see whose license was registered at the address.
Okay, and just so we're clear, I'm not sure we put it on, we're referring to the Law Enforcement Information Network. That's what we're calling Lean.
Yeah, sorry.
Just gotta be clear for the written record. Thank you. Now, so using Lean and public records, that's how you found the name Jonathan Welch connected to that?
Yes, and there was a DD report as well between Talia Frazier and Mr. Welch at that 13,000 Country Street address.
Okay. And now you said you searched and found some records to Kilbourne address, is that correct?
Yes.
And who is that linked to?
Which Kilbourne
address? The 1300?
That one's linked to Jonathan Lamont Welch, or John Welch Jr.
John Welch Jr.?
Yes, that's what it says on the SOS driver's license in law enforcement information.
Okay. What about on the tax record you were searching?
I also came back to Jonathan Lamont Welch, John Q.
Okay, but it didn't come back to Jonathan Welch Jr.
I don't recall if it had Junior at the end of it, but I know it had John, the first and last name, Jonathan, and the last name Welch.
Okay. Well, registered deeds, they generally keep the age of a grantor or grantee. Did it list an age when you looked at the records?
No, I didn't see an age. I don't remember seeing an age.
Okay. When you looked for the Kenosha address, did you look for an age?
It had an age in Lean, since it's law enforcement information network, and their driver's license are registered there. So it listed the full DOD for both Ms. Frazier and Mr. Welch.
Okay. Was anyone else listed at that address in Lean?
I don't remember if there were, no, it's focused on this.
Okay. Now, I want to go to what we're calling video. You reviewed Project Greenlight cameras. Is that a safe statement?
Yes.
Okay. Now, we're talking about you tracking a white car leaving this Kilbourne Street or thereabouts on the Greenlight cameras. Did you run the cameras to see where the white car ended up?
After it left the Kilbourne area? Yes, I also did after.
Okay, and where did it end up?
Last I saw it was Hoover and Sutherland, I believe.
Okay, and did it just disappear or just stop looking?
There weren't any other green light cameras for me to look at. After that, it was.
Okay, and did you look for any green light cameras anywhere near where this white Focus was recovered?
Yes, that was where I had followed to after the Hoover 7. I did not see any other cameras.
Okay.
I could look at.
Trying to get a clear understanding. Before the car, I'm going to back up a time. So before we're seeing this car exiting the Kilbourne area, did you run it back to see where the car came from?
Yes.
And do you know if last stopped or how far back you went there?
I can review my notes and give you the last address I saw at that spot.
Please, if it'll refresh your recollection, absolutely.
Last time was at that was 100% 14651 West 7 Mile Road. It was heading east on 7 Mile. That was at 1:21 a.m.
Okay, and you didn't find it any time before then?
Yes, before then as well.
Okay. Well, how far back did you track it? So I'm trying to get a start point for how far back before the incident on Kilbourne did you look back for the car?
Okay, so the very first time was at 16550 Telegraph, and that's at 11:35 p.m. on June 3rd.
Okay. That was 2022, correct?
Yes, sir.
Just making sure. So you were able to piece together the vehicle's journey from this Telegraph address till where we lose it at Hoover and 7?
Yes.
Most of it, okay. Were there any periods where you lose sight of the car for 15 minutes or more?
Probably around maybe like 15 minutes, probably on the side, but yeah.
Was that before or after the Kilbourne?
That was before.
Okay. And after Kilbourne, did you ever lose sight of the vehicle till the Hoover 7 Mile for a period of 5 minutes or longer?
Let me just check. Camera was exactly 5 minutes. Yes.
When was that?
So 2:59. At one point I saw it at East High Drive in Dickerson. And then the next time I have is 3:11 at it's like East High Drive in Dickerson again. So it looks like it must have parked somewhere.
Okay. We're talking about 12 minutes maybe.
Yeah, basically, yeah.
2:59 to 3:11.
Yes, I agree.
I'm a lawyer, but I'm good at simple math. Okay, no further questions for this witness, Your Honor.
Can you redirect?
Yes, Your Honor. Briefly, Mr. Howell, we had talked about the 586-842-2111 number. What I forgot to ask you was with the number that was texting with it, the 313-636-0697. Did you do anything with that number?
Which number? The second number?
Yes.
Yes, I did.
What did you do with that?
So I used, I mentioned earlier, Spotlight by Thorn to essentially find the number and look at the profiles associated with that number.
What's Spotlight by Thorn?
So it's an investigative tool used for human trafficking investigations.
Is it a law enforcement tool or can anybody use it?
It's a law enforcement tool. You have to request access to it.
Okay. And what is it? What did you do with the number?
So I put the number into, you can search numbers in Spotlight by Thorn. So I put the number into that database and observed that that phone number had made 2 postings on June 3rd and 1 posting on June 4th.
What were the nature of the postings?
They were prostitution posts, I guess, in nature.
And were you able to find out where that number came out to?
Yeah, it's associated with the victim Tyler Morse.
How'd you know?
So her T-Mobile phone number 313-492. See in a second. Can't recall the last 4 digits. 313-492-5693 has also made postings in websites for prostitution and is linked to her 313 text now number through Spotlight by Thorn.
So just to make sure that we got a bunch of numbers coming around. The number that you associated with the victim was used in text now, and text now basically gives it a different number.
So
and that number is what you searched in Spotlight Thorn?
I searched both numbers.
Okay.
T-Mobile number and the text down, which is the 0697.
Gotcha. No further questions. Anything else?
Just very briefly, Your Honor.
Go ahead.
Mr. Al, can you give me that T-Mobile number that you got on Spotlight again, the 492? We're throwing so many numbers around, I want to make sure I have it correct.
So I got that number, I believe, from one of the detectives, and I put it into Spotlight by phone. That number I have on here written down is 313-492-5693.
Okay. And now, did you run all the numbers through this Spotlight by phone or only specific ones?
Only specific ones, I don't know.
Okay, but this T-Mobile number and that, I apologize, the 0697 number? Any other numbers that you ran through?
I did run through Ms. Fraser's number, but I didn't find it right.
And that was the 2111.
No, her number is the 586-222. Excuse me 1 second. 7539. Hers ends in 7539.
Okay, so that one went through Spotlight as well.
Yeah.
All right, thank you, Your Honor. No further questions.
Thank you, sir. You may step down.
Thank you, Your Honor.
People call Detective Officer Emily James.
Request like a 2-minute adjournment, ask the court if they have anything next. It's allergy season, I apologize. Thank you, Your Honor.
Ma'am, please step forward. Give your name and the spelling of your name to the court reporter. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God? Thank you. Please have a seat with the spots next to me.
Thank you, Your Honor. Can you please spell your name one more time for the record?
EMILYJAMES,
And where do you work?
Detroit Police Department,
For how long?
approximately 9 years.
Okay. And what is your what are your current duties?
I currently work at homicide.
Okay, doing what?
We investigate homicide cases.
Does that include drafting search warrants, looking up things from social media, things like that? I'm gonna turn to June 9th, 2022. Did you draft a search warrant for an app named Pinger?
Yes.
And how'd you get to Pinger? How did you get to drafting a search warrant?
Through the victim's phone records.
Okay. Did you draft a search warrant for those?
Yes.
Okay. And do you recall why you chose Pinger?
I had previously submitted a search warrant to Bandwidth, which is what came up here when we ran the phone number. And when I sent them the search warrant, they sent me a response saying that Pinger was the company the phone number was associated with.
Okay. And is Pinger a voice over internet protocol
Yes.
app? And were you able to receive the text messages from the Pinger app?
Through the search warrant return, yes.
Okay. May I approach the witness, Sean? I'm approaching you with what's already been placed into evidence, like Exhibit 4 and 7. And this Pinger app, where was it stored? Do you know?
I do not know.
Okay. Is it in the cloud? Is it?
That I don't know.
Don't know. And does were you able to look at information from the victim's iPad?
Yes.
Okay. Does the iPad, did it have its own phone number associated with it?
No.
So how were you able to get the victim's phone number?
Through, I believe we got it through our report system. And we ran it through here and came back to.
Okay. And with the Pinger records, were you able to find out if were you able to find a number that the Pinger was using?
Yes.
What number was it?
586-842-2111.
Were you able to find out if that number communicated with other numbers?
Yes.
Okay, let's talk about the numbers. We'll look at the top of the document now. It says sender ID, the 2111 number. What was the recipient?
313-636-0697.
And do you know whose number that was?
That is the victim's text now number.
And did you receive that information through a search warrant?
Yes.
Okay. And did you focus on those numbers, on exchanges between those numbers?
Yes.
Okay. And what did those numbers, what were they talking about generally?
It appeared that they were discussing things of sexual nature and prices.
Okay. And was there an address given?
There was
Okay. What was that address?
13010 Kilbourne Street.
Okay. And are they texts in UTC time?
Yes.
And do you know what what you had to subtract to get to the actual time, Eastern Standard Time?
4 hours.
Okay. So if it's, I've already gone. So these were texts, and you thought that they, based on your knowledge and experience, they were discussing sexual type exchange?
Yes.
Now, these numbers, these text messages that you get, is everything that's contained in this document, is that all the numbers that you received? Exhibit 4.
Yes.
Okay. The very top one that says "all right," is that the last one that you received?
Yes.
Did you receive any text messages after that from Pinger? And did you do any research investigation as far as the name Jonathan Welch?
I personally did not.
Okay. I have no further questions, Mr. Witness.
Cross-examine.
Thank you, Your Honor. Is it Officer or Sergeant?
Officer.
Officer James, can you hear me okay?
Yes, I can.
Thank you. So you were tasked with checking clear as it relates to phone numbers, is that correct?
We all typically check out phone numbers, yes.
Okay. How did you get the phone numbers?
Which one?
Any of the numbers that you checked through clear?
So we got the victim's phone number from RMS, our report system. Analyst,
That was the one that ends with 2111?
no, her number was 313-492, I think it was 5693.
Okay.
And Analyst Howell ran that phone number through the Spotlight system, and received her text now number. We did search warrants on that phone as well.
Okay. And I apologize, I'm not great with technology, so I'm trying to just also build a verbal roadmap that I can follow later on down the line. You got a number to check with Clear that came back to being bandwidth originally. How did you get that number?
Through the victim's text now phone records.
Okay, so you'd already gotten their text now records at that point?
Correct.
Okay. So in what number was the text now?
The 313-636-0697.
Okay, but that was the text now number to the victim. That gave you the clear search that led you to bandwidth. Is that correct?
Correct.
Okay. And then bandwidth response to your warrant says it's finger?
Correct.
Now, was that an email or? Okay. If you know, is there any connection or affiliation between bandwidth and finger?
I believe bandwidth may own Painter. I'm not.
Okay.
I'm not certain.
You work with it, so I figured you may have a better understanding than I do. Okay, so now you look through the records and the prosecutor pointed out that it appears to stop on June 4th. Is that correct?
Yes.
On the longer document? Last one we had is June 4th.
Correct.
Can you go back to the last page? And it appears that there's a date on that last page of 6/2.
Yes.
Okay. Now, this is what Panger provided you based on the search warrant?
Yes.
Did you ask for a period prior to 6/2 and that's all they gave you, or?
I would have to look back at my search warrant to see what dates I requested.
Okay. Would you typically just request like a 2-day snapshot, a 4-day, a week long?
I typically request 6 months.
6 months? Okay. So if you had requested that, this is what Panger provided.
Yes.
Okay. And now the other document, the shorter of the two, exhibit 7.
Yes.
Exhibit 7. Were you provided that document? Okay, so you don't recognize that document.
I've seen it, but it was not provided by the company.
Okay. You didn't produce that document. That's
No.
not something you gave to somebody else or otherwise helped produce or collate into something. All right. No further questions. Thank you, Your Honor.
Just a quick one. The June 4th number, the June 4th text, in your search warrant, you said you request 6 months. Do you typically request up to present
Yes.
time? Okay, so anything up to the date of the search warrant, you would ask for as far as what recency is?
Correct.
Okay, no further questions.
Thank you, ma'am. Mr.
All right, I have no further questions or no further witnesses now. The only thing I have left are the exhibits that I placed into evidence that I would like to publish. Okay. The first one. I believe it's exhibit 6 for the FD report. It's a joint fire department fire investigation report authored by Lieutenant Joseph Crandall. And he basically, I won't read the whole thing, but he basically says that a 2018 Ford Focus was found at Lappin and Bedland in Detroit in an alley, and it was impounded. It was fire damage to the exterior of it, originating from the passenger compartment. And it goes on to, there's some pictures of it. And there are, he goes on to talk about the fire cause. And on the page 6 of 7, he says that first material ignited vapors of an accelerant such as gasoline. Ignition scenario, accelerant distributed, ignited, and evidence is a floor mat in the driver's side rear floor with odor of accelerant such as gasoline to be submitted the Michigan State Police Crime Lab for analysis. And the next page is the opinion of this writer that this fire was incendiary in nature, originating from the vapors of an accelerant distributed to the passenger compartments, driver's seat area, causing substantial fire damage. And so that would be exhibit 6, and then finally, I think exhibit 8 is the laboratory report.
I just apologize, and I'm trying to keep this straight. The proposed exhibits 1, 2, and 3 initially were the ME report, the state police report, and I believe that forensic, the fire department report on the car. So I'm just trying to make sure we're keeping the numbers straight. The 3 stipulations we did for 1, 2, and 3. I know what he's calling 6 might actually be 3.
I went out of order because I have video is going to be. I just did them as I went along. So whatever it says on top of the page is what we said.
So Detroit Fire Department Fire Investigation Report is exhibit 6.
And then I believe the laboratory report from Michigan State Police is exhibit 8, if I'm not mistaken. Exhibit 8, okay. So they can bring that up. So, this is a laboratory report done by the MSP lab, and they took a buckle swab of the victim, vaginal swab of the Italian Morris, buckle of the Italian Morris, the victim, vaginal cervical swab, another vaginal cervical swab, and then a buccal swab of Jonathan Welch. And they came to the conclusion that based on the DNA typing results obtained from the vaginal wall cervical swab, fraction 2 is approximately 260 octillion times more likely if the DNA originated from Italian Morse and Jonathan Welch than if the DNA originated from Italian Morse. And the analysis provides very strong support that Jonathan Welch is a contributor to the vaginal wall cervical swab of fraction 2, which is the Italian Morse. So at this point, people don't have any more witnesses for today. We have one more witness, Trayvon Wilkerson, who will testify basically to the video that was referenced earlier. He'll and obviously we'll get the video in through him. I do not have that person here. I believe I need the person, but if the court feels that it has enough, then I'll go without, but I think I need it.
I was going to ask.
So people are prepared to ask the court to bind over on all charges. And yeah, people are prepared to ask the court to bind over on all charges and seek to make arguments.
Your Honor, of course, we don't believe that people established all the necessary elements for binding over on all the charges. And quite frankly, I don't think we've heard any evidence as it relates to anything related to the arson or anything that puts my client with that car or even driving said car. So I think any and all of the charges against my client as it relates to that, I don't believe the people have met their minimal burden of probable cause standard as it relates to the arson charges or anything else. We've heard no testimony placing my client in a car or anybody seeing him driving the car or any of his DNA putting him in the car. We've heard DNA evidence, what I'm sure we'll be rolling on soon, that may have placed him at or near the victim, but nothing that links my client to that car, Your Honor. So that's what I'm saying.
Mr. Your Honor, so this is a circumstantial case. Absolutely. There is no direct evidence. No eyewitness testified that the defendant committed this crime. However, there's a lot of good circumstantial evidence. So Officer Burst testified when he got to the scene, he saw a woman that had her head, for lack of a better term, bashed in by a cinder block or looked that way. She was unrecognizable. She was killed from blunt force trauma to the head. And we had Sergeant Maida testify that that she did some research, she found who the victim was, Italian Morris, and it came back to Italian Morris based on her tattoos. They went and got the iPad, they analyzed the iPad, and at this point it hinges on the Kinger text messages. So that's what we have here. And these text messages show that the defendant from just the text messages that were received, they reviewed the records. They saw that the defendant was in contact with the victim. The last text message that they received was June 4, 2022 at 1:13 a.m. The victim was killed sometime June 4th. She was found June 4th in the daytime. So she was killed sometime between sometime in the late morning of June 4th, to the early morning of June 4th. There was text messages between the defendant and the victim, and we know that because Officer James testified that they did a search, and Analyst Howell did a search of the text messages or of the phone, and it came back to the victim's phone, which was using an app to mask her number as the 636-0697 number in Text Now. And in Text Now was texting. There was a Spotlight Thorn profile that came back to prostitution type posts. So you take that with these text messages, the Pinger app, which the 586-842-2111 number, and when you look back through the text messages, there are other messages where this person is named Jonathan. And so they take that number, they take the name Jonathan, they take the address Kilbourne Street, and they find, not on 13010 Kilbourne Street, but they find just one number off, 13,000 Kilbourne Street, a house that is owned by Mr. Welch. And they also find that this number is associated with another address that Mr. Welch was associated with Ms. Zalea Frazier, Quail. And what happened here, and so, it's not out of the realm of possibility that he would give the wrong address, especially if he's trying to set up something, some kind of prostitution exchange, some deal. And so what you have are the text trying to set up a deal, and the very last text comes at 1:13 a.m. It's the last person that the defendant or that the victim ever talked to. If you look at her text messages, he's the last person she talked to. Then you find the victim dead, and the car is found at Lappin and Beeland, not in the location, but is found burned. And so I think we got the arson there. And I think based on the text messages themselves, it shows that the defendant and the victim met up for sex, that they did have sex because the MSP results show that they had sex at some point, that after she was found dead, they took a buccal swab and took a vaginal swab, and that it's however many octillion more times likely that he was a contributor to it. So we know that they met up, we know they had sex, and we know that the last person that she had contact with was a person that was associated with a number, that the number says Jonathan. It comes back to an address, 13,000 Kilbourne, where Jonathan Welch owns the house. And not only that, there's another address that Mr. Kilbourne, or that Mr. Welch is associated with that same number. So for probable cause purposes, it shows that the defendant met up with Miss Morris for sex. They had sex, something occurred, he killed her, stole her car, and then in an effort to destroy the evidence, burned the car at a different location. So I would ask to.
How do I know about two different locations?
Because
the car was
found at Lappin and Beeland, and the homicide occurred at Lenox and Canfield. So we know that the car was taken from that location to another location. I'm not familiar enough. I haven't been in Michigan that long to tell you how far away Lappin and Beeland is from Lenox and Canfield, but it's a different intersection at the very least. So, but I can say that is the people's position, that he drove the car away, set it on fire after killing Miss Morris after they met up for sex. And I think the text message is good.
Okay, so let me say this. Did you have something else to understand?
Nothing further, Your Honor. I was just going to stand to address the court.
Okay, so let me say this, that to some degree, the court has handicapped the prosecution, that the prosecution wants to call one more witness, of which that witness has not been located. I indicated at the sidebar that I don't think it's necessary for the people to call that witness, that I think I have enough circumstantial evidence here to bind over the defendant on all the charges, particularly the first-degree murder premeditated. As it relates to first-degree murder premeditated, the court looks at the alleged actions that occurred before, during, and after the homicide. So what we know is that based on these text messages that were going back and forth between the victim, and I apologize if I butchered her name, but phonetically speaking, it looks like the Taylor or the Tyler Morris and the defendant, Jonathan Welch Jr. These text messages would indicate that they did in fact plan to meet up with each other. The physical evidence involved in this case shows that they did in fact meet up with each other at some point in time, given that his DNA was found in Ms. Morris. In addition to that, the last communication that Ms. Morris had, at least by phone, was with the defendant, Mr. Welch. Shortly after that, she's found dead, then her car separated from her as well. So it's not a far leap to conclude that whoever killed her also took her car and burned her car up as well. I'm not sure what this other witness was supposed to testify to, but so far as testimony, evidence that the court has before, the court is satisfied that people have met their burden of probable cause as it relates to all the charges contained in the complaint. The court finds those charges were committed in the city of Detroit. The court finds probable cause to believe this defendant committed. The defendant be found over to Wayne County Third Circuit Court Criminal Division of Drug Proceedings. Is arraigned on the information date and time was May 4th, 2023 at 9:00 a.m. Defendant will be remanded to the Wayne County Sheriff.
Just chill on that for me.
Thank you. Just to clarify, he's on a remand order on this case, correct?
Yes. How many pages for me?
I have multiple
He's gonna remand on another
cases.
case.
One of them is remand, one of those under.
Oh, okay, sorry.
So, he's got two remands.
Okay.
Just to make sure.
That's Chuck.
John, may I retrieve the exhibits?
Yes, sir.
Did it? Thank God.
Still got two of them.
Hey, I think we can take a lunch now, Dennis.
Next one's at 1:30.
Yes, sir. You get the 1:30 as well?
1:30 to 2:30, well, not 2:30.
I'm going to 2:30. Great.
Thank you. Yeah.
All I do is. I don't mind doing it. That's what I don't have to be with it. VLC. Need to watch video.
You bring the paperwork down. We're down to 1:30.
I can't.
Down to 1:30.
Because somebody told me to turn down Elmira too, but based on what we do,
Yeah.
somebody. Pretty sure I signed a bunch of rulings on this case or one of the cases, so. Check what I downloaded.
Yeah. Yeah, and keep in touch.
I appreciate it. Have a great day. I'll be in the building tomorrow. If you can get that number done, correct?
Okay. Yeah.
Thank you too. Be safe, guys.
Thanks.
Lock that door.
Sister Avery. All right now.
Lock the door. You been outside? Huh? You been outside? I'm about to go right now. Did you get my inside? Is the smoke ready? Yeah, I'm gonna lock the door. It's okay. I might have to go there, which is helps. I think I got baggage, so that here. Thank you, that's something.
Hi, Ms. Cross. Hi, Ms. Silver.
Hi, Judge.
Okay. So today is the infamous day.
Me? Yeah.
Are you on?
No, it's me, Judge.
Silver?
No.
I'm here, Mr. Keough. Who is Karina Rodriguez? Anybody know?
That's my, that's my doctor.
All right. So, Mr. Johnson, you have 6 witnesses?
Oh, Judge,
I should have 6 witnesses.
and Judge, I'm gonna object to that,
Object to what?
to the witness, to 2 of the witnesses that have been listed. What do you?
How do you object to witnesses?
Well, because, Judge, you know, I have a reasonable explanation. When we left here previously, there were 3 witnesses that were indicated on the record, but I understand the prosecutor sent an email indicating that there will be 6 witnesses. 2 of those witnesses relate to the 2022 case, and I don't know how many times you have to indicate on the record that you denied the prosecutor's 404B attempt to admit evidence regarding the 2022 case. And Dennis Padina, as we indicated before, is involved in the 2022.
Mr. Johnson, didn't you go over that already?
Yes, Your Honor, and so I subpoenaed them in the hopes that I could renew my motion.
You've already ruled on it. Renew it for what?
The court denied the motion based on the fact that I didn't have everybody here. And I did not have all my witnesses that were not ready to testify. There was some confusion over who was going to testify.
No, that's not exactly accurate. We knew we were coming back anyway.
Right, but
so that's not the reason that I denied your motion.
That's what I thought the reason was because I didn't have them here at the time.
Judge, I'm sorry, there was a
Let's go on the record.
Thank you, Judge. The defendant's not out.
We're going white first? Yes, we're going white. We're just going to do this pre-trial stuff and then I'm going to handle this conference.
I have a question, however. I thought that Mr. Johnson was going to be on Zoom. That's what Arnitha told us last time, that she would get him on Zoom. That's why I didn't come over there.
Mr. Johnson or Mr. Keough?
No, my client, Mr. Johnson.
Johnson.
He's here.
Oh, he's here.
But I'm not. I know, but I'm not there, so.
Well, you'll have time to get here if you like.
Oh, boy. Well, the way we've divided this up is Ms. Kraus is doing some of the questioning, I'm doing some of the questioning, so I'm just not sure.
White is on his way up.
Yes.
Okay. Would it be more helpful if I stay in your corner? Would it be better for you if I'm on Zoom? I can do either.
It wasn't you, that she was her client. That's what they heard.
Mr. White.
What's your name there first?
Oh. Okay, you want me to take it? It's Tuesday. Oh, okay. Right. Okay. Thank you. I appreciate that.
Okay. Calling case 2355491 for the state of Michigan versus Darnell Gary White, been discharged from count 1 homicide for the first degree premeditated. Count 2 assault with intent to murder. Count 3 felony firearm. Count 4 felony firearm.
Good afternoon, Your Honor. Brian Johnson for the people, P84143.
Yes, and good afternoon to this honorable court, Senate Public Ray appearing on behalf of Mr. White, and Mr. Tuttle. The gentleman. He may have gone to the restroom. Do you want me to go? Not going to
Anyway, we were talking about witnesses.
Okay, Judge, at the time that we appeared previously at the preliminary examination, there was a full hearing on a 404B motion. At that time, the court ruled that the 404B evidence would not be allowed. One of the bases that the court gave was that the witness that they were trying to use to get the evidence in did not have a report or an independent recollection. And as a result, the court ruled that the 404B evidence would not be admissible. There was a witness, a Dennis Padina, that the prosecutor intended to call at that time. And I asked for an offer of proof because I read the report and I know that that officer was involved in the 2022 case. And this court indicated that that officer would not be allowed to testify based on your ruling. When I received the email from the prosecutor on 4/17/2023, number 5 is police officer Dennis Padina. And number 6 would be a William Greer. And next to it, it indicates forensic tech from the 2022 scene. And you have indicated that that is not admissible. And as a result, we are objecting to any testimony from those 2 witnesses from the 2022 case. Well, strike that. There was no 2022 case. There was an allegation where my client was never charged and never convicted.
So the 404B motion that I filed had to do with 2 different areas that I was trying to get into. One of them was that the defendant reported his car stolen after this shooting and after the shooting that occurred in 2022. Now, obviously, it's an allegation, he was never convicted. There was also an allegation that he was seen in the area in 2022 by Officer Padina and was seen in his vehicle, which will have somebody identify his vehicle today, and that he was near the scene of the shooting. Officer Padina wrote a report at the time.
Which shooting were we talking about?
The 2022 shooting. Officer Padina wrote a report at the time. I don't recall, to be honest with you, I don't recall one way or the other regarding this offer of proof that Ms. Colbert is talking about. But from what I recall, the court said do you have your people here to testify? Do you have all your people here to testify? And I said, honestly, there was some confusion regarding who dealt with the stolen car thing. And the court said, well, I'm not gonna let it in, not in. I said, well, I have Officer Padina here who can testify to seeing the defendant at the scene at the time in 2022. And the court said, you know, we're done. This case is, I'm denying your motion, full stop.
Judge, may I just respond?
Can I?
Yes, I apologize. Go ahead.
And so, my intention today, obviously, was to put him back on the witness list in the hopes that because I have my people, that the people I intend to call, not for the entire 404B motion, but just the part where the defendant was seen near the scene of a shooting where shells were collected. I'll get into that later, but basically he was seen near the scene of the 2022 shooting in his vehicle. That for that limited basis, I was gonna ask to renew my motion because I have him available, not for the stolen car stuff, but just for the Dennis Medina fact that he was at the scene. I would renew my motion on those grounds only, not to have everybody here.
So how does it make it more probative than prejudicial that he was at the scene of some homicide here?
Judge, there was no homicide. This is not a homicide. This is an alleged FA.
It was alleged FA. So what I intend to prove is that not only was the defendant seen near the scene of a shooting where the defendant's girlfriend was at, who's here to testify. Her name is Paige Hicks. That there were 9mm casings found at the scene, and these 9mm casings came from the same gun as 9mm casings that were found at the scene of this homicide. And that is my offer of proof to show that that it is more probative than prejudicial because for that limited purpose of tying the defendant to both scenes via the bullet casing evidence and the fact that he was seen in the same car as the car that was that we saw in the video at this location.
Judge, may I respond? First of all the witnesses that appear today were here at the previous exam. I was in the hallway and I overheard at the previous exam the witness that indicate Corporal Felicia Manning that indicated that she took the report and that she did not, her name wasn't listed at the bottom of the report and that she did not have an independent recollection of a 2022 incident. That's the first thing. And the second thing, Judge, I respect the prosecutor, but he is not indicating accurate information on the record. I've got the NIBIN-led notifications in my hand, and I do not have a report that says that that is the weapon that was connected to the casing. I see the analysis of casing from a previous 2022 incident, and it says as clear as day, there is a potential link, period. I don't have any report that says that there's a match from anything from 2022 that's related to 2023. And I challenge the prosecutor to correct me when I'm holding the report.
So the report said, the NIBIN report is a preliminary report. It's come in under 766.11b. And what it says is that there is a lead, that there's the potential that these casings match the casings that.
What does that mean, there's a potential?
Well, I mean, that it needs to be verified, but that there is a presumptive match that these casings match. I don't have the MSP report back that shows conclusively that they match, but for PC purposes, the casings match the gun. Casings from one scene match the casings from the other scene. And, you know, I have not personally admitted NIBIN before, but other APAs have, and they've used it for PC purposes only. Obviously, if it goes to trial, we would use the MSP lab report that shows conclusively. But, you know, as far as for PC purpose goes, these are, and then the court can take into account whatever it wants to take into account. But, you know, NIBIN, it basically says that it's a match. And it needs to be verified, but it's a presumptive match. In the same way as, you know, there are presumptive matches that need to be verified by MSP for other things.
But John, Problem being is that
Back to the podium.
okay. The problem is that people want to sit up there and act as if they have a match. They use it, but they use that terminology potentially, and it's a presumptive match. There's no presumptive match. Either it matches or it does not match. You know, you can't presume that if you find a 9mm case one place, and it's a presumption that it's the same, cut from the same gun as the 9mm casing they found somewhere else. And in their 404B motion itself, it says that he may have been the person. So they don't even know that he's the person that was at the prior shooting. They say he may, and we are lawyers, but we understand the use of words. You know, so when he said in his 404B motion itself, that he may have been, what does that mean? And that does have a potential to prejudice our client. It does have potential, but the wording that they use is outcome determinative of what they know. May have been potential match. That's guessing too much.
Judge, if I could just respond, I swear I do really quickly. First of all, again, he stood before this honorable court and indicated that there was a match until it was pointed out that there is no match. That's the first issue. And the second thing is that what he's asking for admission of doesn't even fall within the rules of 404B. He would have to establish, based on his motion, motive, plan, or scheme, or lack of mistake, and it must be material to the conduct at issue in the case. The other acts in evidence must show a significant similarity. We're talking about an alleged felonious assault versus a homicide. Just based on the facts alone, the case law, and Judge, you're not going to stand here and cite it all for you. It wouldn't even be admissible under 404B under the rules of evidence. And he has the burden pursuant to the case law to establish the admission of any 404B evidence that he's trying to admit. There must be a concurrence of common features. Evidence of other acts is logically relevant to show the charged acts occurred if the other acts are sufficiently similar to the charged acts to support an inference that they manifested a common plan, scheme, or system. And that is People versus DOBEK, found at 247 Mish Ave. And that's a 2007 case. And there's more case law that I can cite to the court. It's not admissible, Judge.
So what I gathered, based on what you said, it doesn't look like you're really trying to bring in other acts. You're trying to establish identity through the potential connection between these two scenes and ammunition found in the scene.
Well, yes, and I think it establishes a common scheme as far as using the same gun and using the same product.
Where did we get the same gun from?
Because the Niven says they match.
No,
Yes,
I thought you just said it's a potential.
It is a.
Then that's not a match. A potential match is not a match. So it does not say that it's a match. And if you can tell, I apologize. If you can tell this judge that, Your Honor, they've been tested, if there is a match, then you can do that. If you say potential, you're not saying that it's a match. I'm not sure what part of that is not seeking in.
Just they're using the word match, and the report does not use that word. The words that are indicated on the page 1 of 4, is there is a potential link between casings and something from a previous incident from 2022. No, that's what I'm saying to you, because it just says that there was an alleged shooting at an occupied building or vehicle. So it doesn't specifically indicate what it is they're seeking to admit, but I can for sure tell you that it uses the words on every report that I have. And I'm standing before this court with 2 reports, and both reports indicate that there is a potential link, period.
Yeah, I respond. So, just briefly with this report, I know we're kind of getting far afield on this because but we'll get far afield on it, but I think that, yes, it does say presumptive investigative lead from knife and injury. Evidence may be confirmed by microscopic comparison when requested. But this was done by an ATF firearm examiner, a correlation review specialist. This isn't just some report off the street. This is done by the Bureau of Alcohol, Tobacco, Firearms, and Explosive National Integrated Ballistic Information. It's enough for probable cause. And then, you know, I would love to have the MSP report. Yes, I would. I would love to have it, but I do not have it. I have a potential investigative lead that shows potentially, probably, it just needs to be confirmed that these two bullets came from the same gun. And
let me ask you this, folks. How is it any different than when we have the drug cases? We don't have a final analysis on drugs, but we have something that says that this is cocaine.
There was never a 2022 case, and what he's trying to admit is not even relevant. It doesn't have to be an actual case before B, I understand that, but that's not even relevant to this. How is that relevant to whether or not my client? Well, he's just established, Judge, that I'll stipulate to identity. What the identity of my client? What is he trying to admit?
That your client had a gun with ammunition that was matched to the same ammunition that's verified back in 2022.
But how's that relevant to this case here when there was never a prosecution?
I don't know anything about the case.
It's not relevant.
I haven't heard it. Well, give me a chance. Okay. From what I gather, I don't know, and I hate to speak for you, Mr. Johnson, but from what I gather, it sounds like he's saying that back in 2022, the defendant was involved in some kind of felonious assault, which ammunition was recovered. That ammunition that was recovered is linked to this homicide that's before this court today.
No, he's not saying that, Judge. He's not saying that. He's not saying that, Judge.
He just said he is.
I would like to answer your question.
He's saying, let me just ask, I'm sorry. Is he trying to say that the same, how can that be possible when a gun is fired and a casing comes out and in the 2022 scene? How can he establish that those casings are relevant to an alleged homicide that takes place a year later?
If the casings to that scene match the casings to this scene.
And again, Judge, there's absolutely no report that says, wait, the analysis is not between the two casings. From my understanding, if we could have the prosecutor indicate the report that says that there is a potential link, if he could indicate on the record the evidence that he is seeking to admit based on the report so that the court is clear.
I have the knife and report right here. It shows casing side by side, and I know.
And the casings are from where?
The casings, according to the report, one originated from report number 2094, which is the current case that we're here for, and the other one is from case 220054, which is from the 2022 case. And as far as I read it, and Detective Dawson can testify as well, because he's more familiar with this than I am, that they took both casings, they entered them into Niven, there was a comparison between them, and they were the same, like came from the same gun. Now, I know Mr. Tuttle's and Ms. Corporator are going to say that's presumptive, but that's what the report is saying. It needs to be verified by MSP, but like the court said with the drug presumptive positive, this is a similar situation where for PCC purposes or for preliminary exam purposes, PC purposes, it's enough to get, whether the court binds over on it is a different case. But as far as putting in the Niven stuff under 766.11b, I think it's enough to show that they were the same, that they were fired from the same gun.
See, I did understand.
Okay, so Your Honor, to answer your question, how does this differ from where drugs are involved? Because if the drugs are involved, you do have at least a preliminary analysis on the street.
That's what this is synonymous.
This is, I don't think it is, because there's no person that did some type of, preliminary analysis. And
What's this report that he's talking about?
who is the person that performed this
You guys
analysis?
have a big one, not me, I don't.
Mark Cornell. And peer reviewed by Kathleen Lang from ATM. Similar to, again, 766.11B, it's a lab report, it's not a police report. That's, it's, I think I'll come in.
I still stand on
And the board will put whatever weight it puts.
I still stand on the proposition that this is, this
He doesn't need a final report.
its probative value is substantially outweighed by dangers of prejudice towards our client. That, I mean, that is the position.
Well, of course, it's gonna be prejudicial against your client, it's supposed to be. It's like, well,
I would just ask the court to not allow those witnesses, it's not relevant, and I can say as an officer of the court.
how can you say that's
No,
not?
no, I was gonna indicate that it's not relevant as an officer of the court. I can say based on the discovery in my file, no witness puts my client at that scene. Literally. There is no, he was never even charged with this alleged FA, Judge.
That would be the reason why they use the terminology may.
So, Mr. Johnson, how do you connect the defendant to the prior scene?
He was found, so Officer Padilla will testify that he was seen in his vehicle, Chrysler 200, speeding away from the area of the shooting. Now, to be clear.
How do you place a gun? He's saying to say that gun or the shells from that gun are in possession of the defendant.
Well, I have a girlfriend of the defendant who is, if she's telling the truth, is going to testify that he was in the area of the time. And also Officer Padilla can testify to seeing a video that was never recovered. Seeing a Chrysler 200 in that area. I don't recall if he was firing shots from the car, but saw him like on the street. And then shells were recovered from there.
I think he said that.
The missing piece here, though, that you have to establish. You're going to say that this gun or the bullets or shells from this scene match or may match the shells, bullets, or gun from the homicide. That may be all fine and dandy, but at some point you're going to have to attach the defendant to that prior scene. And him just speeding away from the scene doesn't do it.
I got it at the near the scene, and I got the Officer Padilla testifying to what he saw during his investigation.
And Judge, he does not have him at the scene. Again, he wasn't charged, and the information that the prosecutor indicated on the record is inaccurate. The young lady who was alleged to be his girlfriend, Miss Page, there's a 1 hour and 2 minute and 24-second video that I watched today, and Homicide interrogated her regarding the 2022 case. And
I'm not inclined to admit the 404B because there's not a sufficient connection of the defendant to this prior FA or alleged FA or FA that was never charged.
Thank you, Your Honor.
Just because he was in the vehicle.
Okay.
In the location doesn't necessarily mean that he was in possession of the wound prior to the shot. Okay, let me come back to you guys. I need to switch gears just for a moment to deal with Johnson. You guys are gonna take a lot longer.
I think we're going to be a bit too, but okay.
Thanks, Doc. I can always count. Are we gonna have Mr. Johnson? Okay.
Yes, they don't have Johnson on there, because they thought it was a competency hearing, so I think he had to be over here.
And we call up the conversation from the county. So I was given some wrong information, Ms. Silver. He's not here.
I love it when they're sort of wrong.
You want him present? It only happens once a year. Don't get too excited.
Judge, no comment on that last one, but Judge, I think he should be there. I thought, like I said, I was pretty confident. I think Mr. Kehoe heard the same thing, that we were going to do it. We were all going to be in our offices by Zoom, but Mr. Johnson would be present on Zoom from the jail.
I'm going, while they're working on trying to get him here, I'm going to handle this other matter here that's very contentious as well.
Okay, so you should have the good doctors stand by.
Yes, please. I apologize, doctors. I'm sure you're used to it. Back on the record on people versus Darnell Gary White Jr., calling case 2355491.
Ready, Your Honor.
Mr. Johnson, are we ready to proceed?
Yes.
The next one.
People, yeah, well, I'll address it during argument. People call Andrew Armstead.
Thank you, Judge. Just so that we're clear, there are 4 witnesses that I see left. Was that correct, Mr. Johnson?
I got 2 witnesses on HAs and Andrew Armstead.
Gotcha. Thank you. Only 2.
Only 2.
Thank you.
Armstead. Arms, ARS.
Armstead.
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Thank you. Please have a seat with the spouse next to you.
Thank you. Can you, good afternoon. Can you state and spell your name, please?
Yeah, Detective Andrew R. Arnson, ANDREWRARNTSON.
And where do you work?
Work for Detroit Police Department.
And how long do you work?
7 years.
Okay. I'm gonna take you back to February 2nd, 2023. Around 10:30 that morning, did you find yourself at Sinai Grace Hospital?
I did.
And what did you do there?
I interviewed an individual there who claimed to be shot.
Okay. I've approached it. May I approach the witness, Your Honor?
May I see the document?
Approaching what's already been admitted as People's Exhibit 5. You recognize the person in that photograph?
I do.
Okay. Do you recall what name he gave you?
I don't recall his name.
Looking at your report, fresh recollection?
Of course.
He doesn't have.
You call for murder report?
I took a written statement. I took a written statement.
Judge, I'm objecting to the witness to the prosecutor approaching the witness with the statement. For what purpose? There's no question on the floor. He just simply said that he didn't do a report and he only took a statement. So on what basis is the prosecutor approaching the witness with the statement?
Would it refresh your recollection to leave a statement to determine the name of the person who spoke at the hospital?
Yeah.
And where's the witness from? You may.
Thank you, Judge.
When you're sufficiently refreshed, look up, and I'll ask you the question again.
Yes.
Do you recall the name of the person you spoke with?
Jason Hayes.
Okay. And is that the person that you see in that photograph?
It is.
Okay. And without telling me what they said, did you observe anything about the person in the hospital?
Mr. Hayes was sitting off of the bed, or I'm sorry, he started on the bed. He claimed he had been shot.
Don't tell me what he said. What do he look like?
We asked that, excuse me, there's an objection. And everything on what he said this person said to him. One, and I know we floated out that answer, I said it'd be strict.
So you're going to be making the objections, Mr. Tucker?
Yes.
Tell, what did he look like? What was he wearing?
He had no shirt on. There was I believe he was wearing a hospital gown with
That's
pants
just
on.
speculation. If he doesn't know, he can say he doesn't. When he said, I believe he was wearing a house gown.
I can take it for what it says, because he believes.
And he still had his pants on.
Okay. Did he have any injuries on him?
He had an injury to his right side.
Did you tell what kind of injury it was?
Objection is speculation.
Mr. Speculation.
To him, he's not a medical professional. So he's asking him to speculate to what type of injury. He could have fell into something, could have been stabbed. We don't know. So if he's getting ready.
Tell us what kind of injury.
Yes, I can.
Okay.
There was a shot. I'm sorry, not shot. I'm sorry. A gunshot.
I have no further questions for this witness.
How many gunshot wounds did he have?
I only observed one, obviously.
Which one did you observe?
It was to his right side.
You don't have the, did he strike that? Did he was laying in the hospital bed?
Yes, but not all the way through the interview.
Did he remove his clothing to show you?
He did.
Did you have on a body camera at the time that you had contact with?
I had a body cam set up on the, what's it, the thing that you eat off of, the little table that rolls underneath. So it was sitting right next to me, was right next to me.
Okay, just for the record, I am not in possession of a body camera that this witness is alleged to have had on. So I can move on from that. May I approach with the photograph things? You would agree that the exhibit 5 that the prosecutor showed you, it has a photograph on it, correct?
Yes,
But it doesn't have any writing on it where anyone has signed off on anything, correct?
no, it doesn't have any.
And when the prosecutor initially asked you questions regarding this photograph, you did not know who this was, did you?
I recognized the face, I couldn't remember it.
Okay, give me a description of the face of the person.
The black male, light skin with dreads,
Light skin,
light skin.
like your complexion?
No, darker, more like a caramel type hue, if you will.
And your entire interaction with him was captured on body cam?
Yes.
I don't have.
The judge, the prosecutor has indicated that he doesn't have the body cam. This witness was listed on the witness list. I was able to determine from the investigator's report that he works for homicide. He doesn't have a report, although his name is referenced in the officer in charge's report. And I sent multiple emails to this court. I CC'd the court. I sent them to the prosecutor. I asked for all discovery. And that body cam is critical regarding the identification of the person that is the complainant for count 2. They are trying to get a bind over on assault with intent to commit murder without the witness appearing. And so that appears to be a huge discovery violation because it limited my ability to cross-examine this witness regarding the identification of the person that my client is charged with in count 2, judge. And the prosecutor has indicated for the record that he does not have it. And as we know, the Detroit police are agents of the Wayne County Prosecutor's Office.
Mr. Johnson, where's the video?
I can have Detective Dawson speak to that. I'm looking for my, what I sent to the defense, what I have in my possession. I don't have any body cam video. I assume it exists. I honestly haven't called up to get it.
All right, so discovery is ongoing. It needs to be sent over to the defense court for let's get on that. And discovery, grade, discovery, or
Thank you, Judge Penn. I know the prosecutor indicated that he intended only to call 2 witnesses. So I'll just defer to the court regarding my ability to cross-examine this witness because I'm asking for a dismissal at the end of the proceedings. No. Based on an inability to establish probable cause as it relates to the counts. No, judge. So how do we handle this? The prosecutor needs to provide me with the body cam footage so that I'm able to cross-examine this witness because I submit to this honorable court. I don't think it's true.
Turn over everything I had and I will follow up to get everything that I also have phone dumps that I need to provide to the defense that I received this week as well. So I will. No redirect.
I apologize.
Thank you very much, Your Honor.
That's okay.
Okay, looks like you have Mr. Johnson. Your next witness, Alon Williams.
Yeah, she might be able to.
Let's switch gears here. Got the doctors waiting. Calling case 2257363, people of the state of Michigan versus Demetrius Nathaniel Johnson. Defendant is charged in count 1 homicide, murder, first degree premeditated. Count 2 assault with intent to murder. Count 3 and 4 assault with intent to murder. Count 5 assault with intent to murder. Count 6, 7, 8, 9, and 10 felony firearm. Appearances for the record, please.
Good afternoon, Your Honor. My name is James Kehoe, and my P number is 82812 on behalf of the people.
And good afternoon. I'm Gabi Silver, appearing on behalf of Demetrius Johnson.
And good afternoon, Judge. Sarah Kraus, also appearing on behalf of Demetrius Johnson.
All right, this is the time set for competency hearing. Are we ready to proceed?
Defense is ready, Your Honor.
We're ready to proceed, Judge.
All right, so there is a presumption that the defendant is competent. Who'd like to begin? Ms. Silver?
We can begin if you'd like, Judge. Ms. Kraus?
Yes. I do believe there has been a stipulation as to Dr. Abramski being an expert in forensics examinations. Is that correct, Mr. Kehoe?
I believe it was clinical psychology, but there was a stipulation.
Clinical psychology then.
Dr. Abramski, can you spell your first and last name for us, please? You're on mute.
Sorry. My first name is Atara, A-T-A-R-A. My last name is Abramski, A-B-R-A-M-S-K-Y.
So you have a stipulation that this witness may testify as an expert in the field of clinical psychology, is that right?
Yes, Judge.
That's correct, Judge.
Doctor, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you very much. We may begin when you're ready, Ms. Rose.
Thank you. Dr. Abramski, can you state your name one more time for the record, please?
Sure, Atara Abramski.
And Dr. Abramski, have you testified in court before?
I have.
How many times?
Well, I've testified in court a lot, in probate and in criminal cases, probably if you combine them, dozens of times.
Okay. And as it comes to criminal cases, how many times have you testified?
I would say maybe a total of a dozen.
Okay. And why is that in these types of cases?
Oh, well, if we're talking specifically for competency hearings, I'd say I probably testified 5 times, maybe 6.
Okay. So why so little have you testified in these types of cases?
Sure. So I would say that the primary reason for that is that typically when I do these competency evaluations, over 75% of the time, I'm usually in agreement with the forensic center. So therefore there is no hearing. And then there have been a handful of times where I have found somebody to be not competent and disagree with the forensic center, but they have then revisited the issue and they have found to be in agreement with me. So that therefore there was no hearing then. And then there have been a handful of times where we were not in agreement and it resulted in a hearing.
Were you asked in this case to do an independent evaluation of Demetrius Johnson?
I was.
How many times did you meet with Mr. Johnson?
I personally met with Mr. Johnson once, and then after my initial evaluation, I did send my psychological assistant to see him to do more in-depth neuropsychological testing.
Okay. Approximately how long did you meet with Mr. Johnson?
I was with Mr. Johnson, I would say for 3 hours.
In preparation for your evaluation of Mr. Johnson, did you have a chance to review the report written by the forensic center in this case?
So at the time that I saw him, there was only one report and it was from August of 2022, and I was able to review that.
Okay. Did you agree with the assessment done by Dr. Rodriguez in that report?
I certainly agree with parts of her assessment, or I guess I would say that I understand why she drew some of the conclusions she drew from that report.
Okay. One of those conclusions was that Mr. Johnson was malingering.
Yes, I think that based on her description of his behavior in that evaluation, it was consistent with somebody, it was not consistent with what we typically see when someone is experiencing auditory and visual hallucinations or delusions. And his presentation was atypical, and I can absolutely understand how she would have been skeptical of that presentation and come to the conclusion that he was perhaps faking his symptoms or exaggerating them.
Okay. Do you think Mr. Johnson was malingering?
Well, I think in August of 2022, when he met with Dr. Rodriguez, there is absolutely a possibility that he was exaggerating his symptoms. As I said, I did agree with her that they were unusual and atypical for what we see when people are genuinely experiencing psychosis. My experience with Mr. Johnson was very different, and his presentation with me was very consistent with his presentation with my psych assistant, who went to see him later that month. So while I understand that that's the conclusion she drew, I didn't necessarily think that he was malingering when I saw him.
Now, you kept saying exaggerating. Can you explain that a little bit?
Sure. So when it comes to this idea of malingering, there's a couple different definitions of it. Some will say it is the complete faking of symptoms for secondary gain. Other definitions say it is the faking or exaggerating of symptoms for secondary gain. I think in this case, I do believe that he was probably exaggerating symptoms that had previously existed, or that existed on a smaller scale. And I base that a lot on his mental health history, that there is a lot of evidence that he had some symptoms consistent with psychosis and mood instability prior to these legal proceedings.
What symptoms did you find that Mr. Johnson was not faking?
Well, I think that Mr. Johnson, whether or not he truly hears voices or not, I don't know. But there certainly is a lot of evidence that he has experienced elevated mood, paranoid ideation, sort of a loose association, tangential thoughts, intrusive thoughts. And there is evidence that he has had distorted perceptions of reality, which at times can include auditory hallucinations and delusions.
Does Mr. Johnson have a mental health history that supports the presence of psychotic symptoms?
He did. And, when I spoke with him, it was kind of all based on his self-report. I hadn't read records, but since my meeting with him, I have been privy to a lot of records that, indicate he has had mental health treatment since he was a child. And he's had a variety of antipsychotic medications prescribed to him. He's had hospitalizations. He's had diagnoses of bipolar disorder consistently given to him with psychotic features, consistently given in a variety of settings.
Do you agree that Mr. Johnson is bipolar mixed with psychotic features?
Yeah, when I first saw him, based on, his symptoms, and he was sort of hard to communicate with, I felt at times it was hard to fully understand his thoughts and feelings when I met with him. I diagnosed him with schizophrenia at the time. However, I have since had the ability to read the records. It does look like he's had some pretty significant manic episodes wherein he's been elevated, animated, agitated, violent, really impulsive. And so I do think that a bipolar disorder with psychotic features would be an appropriate diagnosis.
Okay. Did you have an opportunity to observe Mr. Johnson's behavior during your assessment?
I did.
What were your observations about his behavior?
Well, one of the things was that he could provide a history for me. He tried his best. At times he was a poor historian, but we were able to kind of get through his history a little bit. But he really had a hard time articulating his thoughts and feelings. He also did endorse some, bizarre and unusual thought content, a lot of, and he had a hard time explaining it. It didn't seem like something he was able to articulate really well, but there was a lot of this idea that, what we call like derealization, like this isn't really happening. Maybe this isn't a real thing. So that was part of my behavioral observations. I did think that he was effortful in his approach to testing, as noted by my psych assistant, but his vocabulary is very limited. His thought processes are concrete, at times impoverished, and I had a lot of questions about his cognitive functioning when I met with him.
Okay. And you said Mr. Johnson participated in some testing.
He did.
Okay. How many assessments was he given?
He was given a full battery, which is lengthy and somewhat tedious and very tiresome, but he did participate. And he was given several things. He was given an IQ test. He was given a test that further measures cognitive functioning. He was given an achievement test that measures things like your reading, writing, and math skills. He was given the spectra, which just assesses him for mental health issues, social and emotional functioning. He was also given a test that we use to determine if somebody is trying to feign their cognitive symptoms. That's a test of malingered memory. And those were the tests that were administered to him.
How did Mr. Johnson perform on his IQ test?
So Mr. Johnson ended up with a full scale IQ score of 70, which is in the borderline range of intellectual functioning. It is not considered low enough to be an intellectual disability, which was formerly known as mental retardation, but it was close. It shows some pretty significant impairments.
Okay. And on the immediate memory test, how did Mr. Johnson perform on that test?
Which, I'm sorry, specifically, which test are you talking about?
The repeatable battery for the assessment of
the R-bands? Yeah, I mean, his performance varied there too. I mean, overall, it was considered, he had areas where he was extremely low and areas where he was borderline. His attention was actually deemed to be low average. So he was a mixed bag there. It was somewhat consistent with his IQ testing.
Okay. What about the academic achievement test?
So basically in the, what we call the core subjects, we've got your reading, your writing, your math. He varied between a 4th grade and a 6th grade level, which is almost consistent with his reported education level that he stopped going in the 8th grade.
And you also gave him a test that measured malingering.
Yeah, we gave him the TOM, which is a test of malingered memory. It's a test that has been shown to be something that even somebody with something like dementia or a traumatic brain injury can do quite well. And we use it to sort of gauge if we think they're being effortful in their approach to testing. He did just fine on that.
Okay. Did Mr. Johnson appear to be putting forth effort while he took these tests?
Yes, I think he was putting forth effort. There were things, for example, my psych assistant chose to read the questions to him on the spectra. She had to rephrase things several times because he didn't understand, but she noted that he was thinking about his answers and trying to respond, thoughtfully. Also, his scores are not that low. So if he was really faking his symptoms, we would expect to see much lower scores. Based on my experience, I give IQ tests often, and I do them for disability. So there's obviously, there's reasons there for people to try to attempt to score low. So I would expect to see much lower scores if he was not being effortful in his approach. And again, he did just fine on a test of malingering.
Was there a second report written by the Forensic Center?
There was. Dr. Rodriguez, I believe, did a second report or an addendum to her first report primarily based on the records that she was able to obtain in March of 2023.
Did you have an opportunity to review that report?
I did.
Do portions of that report include jail health records for Mr. Johnson?
They did.
Okay. And those were from May to October?
Correct.
Okay. Did Mr. Johnson's symptoms progress during that time?
They did. So it looks like when he first came in, he was reporting symptoms and a history consistent with bipolar disorder, psychosis. He was reporting auditory and visual hallucinations, mood disturbances. And then there's a lull and he doesn't report much. And then it looks like in October of 2022, his self-reported symptoms increased and he seemed to be really struggling and he was reaching out trying to get treatment for these symptoms.
What could have caused that shift in his status?
Yeah, I would wonder if maybe the stress of jail was getting to him. It's not uncommon. I have seen this before in my clinical experience. The longer somebody sits in jail, they start to decompensate. They are bored, they are nervous, they are anxious, they are scared. And these are all triggers to episodic mental health, which, mental health symptoms often do come in episodes, especially with a diagnosis like bipolar disorder. So that is perhaps, what was happening, maybe getting closer to, resolving this case, things like that. And he really seemed to decompensate. It looks like, the reports from the jail are sort of a mixed bag, but in October, it did appear that the people that were evaluating him were documenting what they seemed to be some genuine symptoms. And he was placed on medications to treat those symptoms.
From all of the information available to you, were you able to come up with a diagnosis for Mr. Johnson?
Yeah, I would agree with the diagnosis of a bipolar disorder with psychotic features. I think that is appropriate given his history and what we've seen in the records prior to him entering jail.
Did you also give an opinion on Mr. Johnson's competency?
I did. So when I met with him and I tried to assess him for issues of competency, I found that he was hard to communicate with. I thought that he had a lack of understanding of the legal system and the role of the participants. I believe there's a lot of reasons that he might have that lack of understanding. And then also I felt that at the time he was exhibiting symptoms and he had ideas in his mind that would make it very hard for him to consult with his counsel and be an integral part of the legal process.
So in your opinion, does Mr. Johnson have the ability to understand the criminal process?
I think he does, but I don't think he does right now. And I think it would take education and some. I think he has the ability, but I think that he needs education, and I think it needs to be presented to him in a way that will make sense for somebody that has the impairments he has. And then I think what's happening is if you add this mental health component and the fact that he's unstable mentally, it's exacerbating his overall prognosis, and would make it much harder for him to focus, concentrate, absorb the information. And that was part of where I drew my conclusions from. It's sort of this combination of these impairments he has cognitively and his mental health symptoms combined that make him, vulnerable.
So what kind of treatment would you recommend for Mr. Johnson?
So given the circumstances, my thought was that perhaps he needed to go to the Center for Forensics for more intensive treatment. He is in a very stressful jail environment right now. He is taking medications, or he's prescribed medications, but other than that, he's not getting any treatment. It is a very stressful environment. And I think that he would probably do well in the structured supportive environment of a hospital setting, where he could hopefully be restored to competency by improving the overall quality of his mental health, and also hopefully some education on the legal system and his case presented to him in a way that helps him understand it better.
I have nothing further, Judge.
Mr. Kehoe.
Thank you, Your Honor. Good afternoon, Dr. Abramsky. How are you?
I'm good. How are you?
I'm well, thank you. I know we're over Zoom, so if I cut out for anything, please just let me know. Still getting used to this. So I want to start with, I guess, generally with your background. Were you able to review any of the records related to Mr. Johnson's prior mental health treatment as part of your opinion on this case?
So I was able to review them recently, but at the time that I rendered my opinion on this report, I had not seen anything other than what was summarized in Dr. Rodriguez's original report from August of 2022.
Certainly. And just so we're all on the same page, are these the same records that Dr. Rodriguez mentioned in her supplement to the competency report?
Yes, but I was able to view the actual records, not just glean them from her report.
Okay, certainly. As it pertains to the those records, I guess we'll start with the jail records that you received. How did those inform your opinion between your initial written report and where we are today?
Well, they didn't really change anything in my report other than maybe a reconsideration of the diagnoses. It kind of validated what I thought, because what we see is sort of a progression of his symptoms and a decompensation, which again, I've seen multiple times in jail. The other thing I saw that I thought was really interesting is that after he's medicated, he is reporting that he's feeling better and that he's presenting differently, indicating that the medications were actually pretty effective in treating some of his symptoms.
So if you, well, first, I guess I'm going to stick with your initial opinion and then kind of to your new diagnosis. So initially you diagnosed Mr. Johnson with schizophrenia, was that correct?
Correct.
Okay. My understanding is now that based on your review of the records that were provided to it, and I want to make sure I got it right, it was bipolar with psychosis effects, was that correct?
Bipolar disorder with psychosis, severe. I believe it was a mixed episode that they said in the diagnosis, but it's bipolar disorder with psychotic features.
Thank you. So what exactly does it mean to be diagnosed with bipolar disorder with psychotic features?
Sure. So bipolar disorder is an affective disorder. It usually it implies that somebody experiences episodes of what we call mania. Mania is usually characterized by this really elevated mood, animated affect, impulsivity, racing thoughts, a decreased need for sleep, very self-destructive behaviors. Oftentimes bipolar disorder is also marked by depressive episodes. And when you see something like a mixed episode, which you saw which we see in the documents, that means that he's having symptoms of both. And then with psychotic features means that in addition to these symptoms, and especially when he's in a heightened state, psychotic symptoms will accompany these episodes.
And so with that bipolar disorder, I apologize, you indicated that one of the main features of that would be kind of like a manic instances of mania.
Instances of mania, which I think were documented more in the records that he and I didn't discuss as much.
For sure. As part of a bipolar disorder with psychotic features, does that accompany any sort of, would a symptom of that be hallucinations or distorted reality, I believe is what you called it?
Sure. So that's where we would get the with psychotic features portion of a bipolar disorder.
Okay. And then how often throughout the records did you observe the prior instances of those psychotic features?
Well, it's documented throughout the records. Almost any time he had a mental health contact with mental health providers, he is endorsing something associated with psychosis, whether it's paranoia, flight of ideas, tangential thinking, auditory or visual hallucinations. So they're seen throughout. And even if you go back to his initial evaluations at Higuera when he was an adolescent, we don't see psychosis, but we see sort of that destructive behavior, impulsivity, acting out, poking himself with safety pins, temper tantrums not consistent with his age. And oftentimes those are precursors to a bipolar disorder. Not always, but often.
No, certainly. But as part of that Higuera, those records, there wasn't any diagnoses other than the ADHD and depressive disorder. Is that fair?
Correct.
Okay. And then I believe the next available medical records we had after Higuera were the core psych records.
I think there was a hospitalization at Garden City before the core psych. I believe he was referred, if I recall correctly, he was referred to core psych from Garden City.
No, you're absolutely correct. I apologize. I skipped over it. Now, as part of that, at that time, at least, Mr. Johnson had indicated that he had no prior hallucinations or no self-reporting of anything like that. Is that fair?
At Garden City?
Yes, ma'am.
Yes, I believe that was reported by him.
Okay. Is it typical for someone with bipolar disorder with the psychotic features for these distorted reality hallucinations to kind of elevate as they get older within a patient?
Well, he's only 21 right now, so he's sort of in the thick of when we see these things starting to, really heighten. Yes, as people get older, and 30s, 40s, 50s, people sort of stabilize, they age out of some of these symptoms, but right now he's in the thick of where we would expect him to be experiencing significant symptoms.
Okay. And it was from that stay at the Garden City Hospital back in 2021 when he was first diagnosed, I believe, at least within the reports, of bipolar 1 disorder.
I'm not sure if that was the first time that it was diagnosed, but I think that's the first time from the documents we gleaned.
I apologize. You're correct from the documents we have. And then it was from the Garden City stay that was when the core psych evaluation started. Is that correct?
Correct.
Okay. And then from there, when he was at the core psych, he was given and prescribed, is it risperidone?
Risperdal or risperidone.
Okay. What kind of drug is that, Dr. Abramsky?
It's an antipsychotic.
Okay. And it was there again that he was also diagnosed with bipolar disorder?
Correct.
Okay. Do you know, is there a particular reason why somebody would be diagnosed with an antipsychotic as part of a bipolar disorder diagnosis?
Well, his bipolar disorder includes a psychosis component. So that's part of it. Sometimes antipsychotics are given, as a mood stabilizer or as a medication to, keep somebody more calm as well. But there's a psychotic component. And I think from the way that the core psych evaluation describes him, whether or not he was endorsing these symptoms, he was presenting with symptoms consistent with a psychotic disorder, such as tangential speech and paranoia and things like that I believe are in here.
Certainly, but apart from, as the records described as kind of his unrealistic decisions as part of his core psych, I guess we'll say medical records, was there anything that stuck out to you as part of those records that stuck out to you in terms of a psychosis?
Well, I think I'm just trying to look now. I believe he's described as paranoid. And his speech is tangential, but let me make sure I'm looking at the right ones. I don't want to misspeak.
Certainly.
Let me pull it up. Yeah, so his thought process was racing. His attention and concentration were preoccupied and easily distracted, unrealistic decisions, all of those things.
And what would those symptoms indicate to you, Dr. Abramsky?
Mania, distorted perceptions of reality, internal preoccupation, possibly from, when you say someone's preoccupied and easily distracted, sometimes when someone's experiencing psychosis, they're paying more attention to what's going on in their head or voices that are coming from the outside, and that results in a preoccupation and distraction.
And then lastly, Dr. Abramsky, I believe the only other medical records we had were from the Wayne County Jail. Is that correct?
Yes, there was some stuff from Team Wellness, which proved to be essentially nothing. And then there were the records from the jail.
And I believe, Dr. Abramsky, it was that first time that there was a concern of the distorted reality is that Mr. Johnson self-reported was back in October of 2022.
Well, I think he initially came into the hospital. I mean, when he came into the jail in May, he was reporting a history of symptoms and that he was experiencing symptoms, and then later kind of reneged on some of those symptoms or said that he was okay. And then they kind of flared up again in October.
Sir, and I agree, Dr. Abramsky, that going back to those May records, he indicated that he had a report of depression, but there wasn't anything beyond that to indicate hallucinations or anything like that, was there?
Hold on, I'm pulling it up. Let me see if I can find it. Let's see. So where are we? So let's see. This is in May. Okay, sorry, I'm searching for the notes from May.
No problem. I know this is a lot of paper, so take your time.
Okay. Let's see. I know there was a narrative in here that I looked at. Let's see. Feel like I'm close. Hold on. Let's see. Are we still in May? Yeah, this is still May. So I think he was placed on suicide precautions in May of 2022, based on his reports. Okay, so what was he? Yeah, he had reported that his mind was messed up and that he was experiencing depression. And that's all I see from the May reports, and that he was placed on a suicide watch based on his report of symptoms.
For sure. And then,
yeah, he was reporting being suicidal, thinking about taking an overdose, no specific plan.
so I want to next turn to Dr. Abramsky, the IQ testing you did, or your office did with Mr. Johnson.
Sure.
You indicated that he was either in the low average, or borderline IQ range. Is that fair?
I know he's very much in the borderline range, his full scale IQ. Some of his subtests were in the low average range, but overall he's very much in the borderline range.
Okay, and what does it mean just in terms of plain speak, what does it mean to be in the borderline range?
Yeah, it means that you certainly have a lot of cognitive challenges and a lot of deficits, and that while he doesn't meet the full criteria for an intellectual disability, it's on the border. It's something that is an area of concern. It means that his cognitive processing is slower than somebody that's in the average range or even the low average range, and he does have impairments.
Sorry, Dr. Abramsky, I'm just trying not to be repetitive. I know we went through a lot of this earlier, so I'm just going through my notes. I want to go to the TOMM test, Dr. Abramsky.
Okay.
What are those tests for?
So it's a test to see whether or not someone's malingering a poor memory, essentially. What happens is when we give these cognitive batteries, it's like a validity measure that we can use to determine whether or not we think someone's being effortful in their approach. So they see these pictures and then they're shown them again. And the idea is whether or not they remember the pictures they'd seen before. And you know, as I said before, what we have found is that even people with traumatic brain injuries can do very well on a test like this. It's something that most people should be able to do fairly well on. So when we see people scoring really low on them, it indicates to us that they're not putting forth effort or that they're intentionally trying to look bad.
And this is a test, though, just to test that the immediate memory. Is that what you said?
Right. The idea is when somebody is trying to fake their symptoms, they'll fake on across a variety of settings, and we will see extremely poor performance that's, you know, unrealistic, and that's what the TOM captures.
Does the TOM test have any way of determining how truthful somebody is being? Or you talked about exaggeration earlier. Is there a way that how does it interact with that finding?
So if someone scores really poorly on the test, what we can say is that we don't think they're being effortful and that they are trying to appear more impaired than they are. When they do well on the test, it indicates to us that they are perhaps putting forth good effort, that they're putting forth good effort on that test, that they're giving a realistic presentation on that test. And what we do is we sort of extrapolate that to say that it helps us to determine that perhaps they're being effortful on the other tests that we're giving them as well.
And so, Dr. Abramsky, then turning to the legal knowledge test, is that what it's called?
I didn't give him the test of legal knowledge.
Okay. When you spoke to him about the roles of the different people within the courtroom?
Correct.
Now, initially, I believe you stated he didn't really have a good understanding or any understanding of what everyone's individual role in the courtroom was.
No, very, very little understanding. Like I said, the conversation was not very meaningful. I did try to work with him and he still seemed to have little knowledge.
Did you, as part of that conversation with him, did you explain to him what the different people in the courtroom were?
Well, no, I mean, the idea was to see whether or not he knew. I did try to work with him on certain aspects to see if he would sort of gain a better understanding or to try to assess his ability to learn these things. And he didn't fare very well in that area. He knew certain things, but very, very limited.
So while you're gauging his ability to understand and learn those different aspects, how did you evaluate that? What did you specifically do?
Well, I specifically asked him to tell me what a prosecutor does. What's your attorney's name? Is she the defense or the prosecution? So I just asked him about these things. And then, I kind of tried to work with him on like the difference between first and second degree murder. He didn't know. So I sort of worked with him. I sort of explained it to him. And then I posed the question back to him. And he still didn't seem to have a very good understanding.
At any point during your conversation discussing the difference between first and second degree murder, the different people within the courtroom, how did he appear to you when you were having this part of the discussion?
He appeared sort of vacant. I don't know if that's a good word. I mean, he just didn't seem to have a great understanding. Like I said, his vocabulary is poor. His ability to articulate his thoughts and his feelings is poor. So, you know, again, while he can, you know, try to dig up facts about his childhood or about, you know, how he went in school, he can report some of that stuff, but he really has a harder time with critical thinking. At least he was on the day that I saw him.
Dr. Abramsky, you also indicated that he was either unable or unwilling to discuss the criminal process. Why did you say that he was unable or unwilling to discuss that process?
Well, we didn't have a very good conversation. I did find him hard to communicate with, and I can't say for certain whether it's because he didn't know or he didn't want to discuss it with me. I mean, that's not something that, you know, I'm not a mind reader. I don't know. So, you know, I err on the side of caution to say it's one of these two reasons, but I just did not feel that we were able to have a good conversation, and I did not feel confident that he was understanding what was going on. And again, this was sort of consistent with what we saw of him throughout our two evaluations with him.
And when you had this, I know I keep asking a lot of specific questions about this, Dr. Abramsky. When you had this conversation with him about the legal process, was that part of your first evaluation of Mr. Johnson, or was that with Ms. Toth on the second evaluation?
That was from my evaluation, and it was part of the reason that I decided I wanted to do more testing with him to kind of try to get at what his cognitive functioning is, what areas, what domains he really struggles with, you know, and you know, what his functional limitations might be.
Kehoe, did you have anything else?
Sorry, Your Honor, I'm just going through my notes really quick. I apologize. No, Your Honor, I don't believe I do. Thank you, Dr. Abramsky. I apologize for that.
Ms. Cross, you have any redirect?
No, Your Honor.
Thank you, Dr. Abramsky. Oh, I do have a couple questions for you.
Sure.
How did you say he performed on the lingering test that you gave?
He passed. He did well. There was no indication of deception.
You mentioned something about exaggerated symptoms. When did that come into play?
So when he met with me, I did not feel that he was exaggerating symptoms. You know, the crux of the evaluation I reviewed from the forensic center was that he was faking psychosis or auditory hallucinations and delusions, and therefore, because he was faking, he was competent. So what I would say is that based on his history, I think there is a lot of evidence that prior to having legal problems, he did have a mental health history and that there were symptoms that were consistent with psychosis. However, his presentation in August with Dr. Rodriguez was not realistic. And I believe that he was probably, for one reason or another, exaggerating those symptoms. I'm not sure why he was doing that. I can only speculate as to why I think he would do that. But I do believe that those symptoms were exaggerated. Oftentimes what we see with malingering, from the research I've done on malingering, is that malingering starts from a true symptoms that gets exaggerated. And I believe that might be what happened. For example, I'm sorry, go ahead.
Specifically, what symptoms are we talking about?
Well, the symptoms that Dr. Rodriguez was extremely focused on, you know, for example, he kept saying he was an archangel, right? This was like sort of the crux of this, the theme of the first evaluation he did with him, and why he was so hard to assess is that he kept talking about being an archangel. I think it's possible that he's had those experiences in the past. And in fact, when I talked to him, without me bringing anything about an archangel up, when we were just talking about his history, he said, yeah, in the past, I've thought I was an archangel. So it's possible that that's something he experienced at the time.
I didn't hear you. Can you repeat that? He said what?
He said, yeah, in the past, I've thought I was an archangel. You know, like to me, he was reporting it as something, a symptom that he's had in the past. He was not trying to present as, you know, having that belief at the moment. So for example, so that's what we talk about exaggerating. It's possible that he's had that belief, but at that moment with her, for whatever reason, you know, he may have been exaggerating that.
So help me understand your conclusion that he's not competent to stand trial at this time. Is it because he's unable to comprehend or understand who the important players in the courtroom are?
Well,
or that there's some kind of psychosis that's going to interfere with his ability to help assist in the defense?
So that was my more primary concern. I certainly think he has the capability to learn if he's taught with repetition, the role of the prosecutor, the role of the judge, the role of the jury. I think those things are possible. And we see that, you know, even with his IQ of 70, he has some strengths. I do believe that's possible. My main concerns were his complete inability to understand the severity of his circumstances, saying things like, well, I had a dream that everything was okay, and my dreams usually come true, so it's going to be fine. He cannot entertain, he could not, when I met with him, entertain a rational conversation about what happens if that's not the case. What, you know, what kind of strategies do you want to use for your defense? Those were just things I didn't see. So this idea that there's lack of evidence and that his dreams come true and that he doesn't think this is even a real thing, it seems like a simulation. I don't understand how he can, you know, function in the legal process while he maintains those beliefs. And I think those are the aspects of his presentation that can be stabilized further.
Do you believe that if given antipsychotic medication, that it will better his condition and he would be competent to stand trial?
Well, he's being given antipsychotic medication. And, you know, I think there have been maybe some improvements, and his self-report in the records shows that some of his symptoms have improved. I think what we're seeing is what we call breakthrough psychosis, that he still has some symptoms that are persisting. And I think that he just requires a more therapeutic environment to get to what we call his baseline. I think it's probably very hard for him in jail. I hope that he is medication compliant. I don't know how the jail you know, makes, you know, sure that
what are the symptoms you're referring to again?
Again, the sort of the magical thinking, the derealization, the you know, the bizarre belief of the, you know, it's a simulation and it's everything's going to be fine because I had a dream it was going to be fine. And then I think he also does need more education on the legal system, and I would hope that that's part of the restoration to competency that they provide at the Forensic Center is education.
Any questions based on my questions?
No, Your Honor.
All right, thank you.
Thank you, Dr. Abramsky. Appreciate your time.
Yeah.
You guys were a lot longer with Dr. Abramsky than I thought. We went back to the exam tool. Switch gears. I apologize, Dr. Rodriguez. Give me just a moment, okay?
Sure.
Back on the record on People versus Darnell, Gary, White.
Ready, Your Honor.
So, Your Honor, the witness that I was intending to call next thought she could leave. Nobody told her she could leave, but she took it upon herself to leave. Detective Dawson called her back. Allegedly, she's back on her way. We'll be here in 10 minutes. I have not verified that with her.
And Judge, I might indicate that the only reason they know that is because Attorney Tubbs and I made a decision during your hearing to interview the witness in the presence of the prosecutor.
Switching gears again. Back on the record on People versus Demetrius Nathaniel Johnson. Dr. Rodriguez, good afternoon.
Good afternoon.
Oh, can you spell your name for us? Rodriguez, first and last name, please.
Sure, it's KARINARODRIGUEZ.
Mr. Gino?
Thank you, Your Honor.
Sorry, Dr. Rodriguez, please raise your right hand. You swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you very much. Okay, Mr. Gino.
Thank you, Judge. And Ms. Kraus, did we still have the stipulation for the expertise in clinical psychology?
Yes.
Your Honor, I would move to have Dr. Rodriguez qualify as an expert under Michigan Rule of Evidence 702 in the field of clinical psychology.
So, or this witness may testify as an expert witness in the area of clinical psychology. May proceed.
Thank you, Your Honor. Good afternoon, Dr. Rodriguez.
Good afternoon.
So I want to begin with your initial evaluation of Mr. Johnson. When you receive a case like this, what is the first step in your evaluation, Dr. Rodriguez?
The first thing I do is I review the court orders provided to us at the Forensic Center, and there were court orders for competency and criminal responsibility evaluations. So I reviewed those, and then I attempt to consult with the defense attorney, which in this case I was unable to reach the attorney, and I didn't receive a call back in time for the evaluation. I then conduct a forensic evaluation or forensic interview with a defendant, typically in the jail. And then finally, I review records typically from the jail, Wayne County Jail in this instance, and then other hospitals or outpatient treatment facilities, if warranted.
Let's go back to first your initial evaluation with Mr. Johnson. How did that go?
So I evaluated him via Zoom at the Wayne County Jail, and it lasted approximately 15 minutes. This was on July 28th in 2022. And the way he presented, he wasn't very cooperative. Whenever I tried to ask him questions about his current adjustment at the jail, or if he knew what he was charged with, he just kept telling me that he was an archangel. That's exactly what he said. He was interrupting me quite a bit. He was pacing back and forth in the cell. He made statements like, "I'm an archangel. This doesn't concern me." He said, "I'm an archangel. We won't age. I've been on this earth 1,000 times and I'll be back." And so I did ask him what the date was, because just based on his presentation, which was pretty atypical of what I usually see with defendants who are experiencing true, genuine psychosis, I asked him, "Oh, do you know the date or the year?" And he said it was 2015. And typically people who are very delusional or experiencing psychotic symptoms, they know the year or the approximate year. And even if they don't know the date or the month, they'll know the year. And he was unable to provide for me his date of birth as well, which is highly unusual. You would see that typically with someone who has like, dementia or some sort of brain injury, things like that, which he doesn't have per the records.
And
So,
Dr. Rodriguez, I want to just kind of break it up a little bit. How long was your conversation with Mr. Johnson when you had this initial evaluation?
approximately 15 minutes.
And after you assessed by asking him the date and what year it was, what did you do next as part of that conversation?
I asked him where he currently was. Usually, which jail are you? How long have you been there? He ignored those questions completely, and he just said, "I've been kidnapped. I got to make it back to heaven. I'm not supposed to be here. I'm an archangel. I'm from heaven."
After asking him where he was, were you able to have any sort of conversation with him thereafter?
Not really. Anytime I tried to ask him about, do you know what you're charged with or anything regarding just his current adjustment in the jail or just any kind of legal questions, he ignored them completely and just kept talking about how he was an archangel, how I'm going to pay for this. He said that several times, you're going to pay for this. I'm supposed to be in heaven. And then he eventually just refused to answer any of my questions at all. And that's when the interview was prematurely terminated due to his unwillingness to continue.
And then after this, well, first, when was this first initial interview?
July 28, 2022.
After that initial interview back in July of last year, what was your next step in this process?
So just based on how he presented, I was already suspicious that there might be an issue of malingering, but I wanted to get more evidence. So I requested the records from the Wayne County Jail. And so, as I said, I had initially met with him on July 28, 2022. So I requested any records from the jail from 2022, currently when he was booked. And at the time, I reviewed records from May 24th, 2022 to July 12th, 2022. So this was the most recent being a little over a week after I had initially met with him. And so what I found that was striking was that, let's see, he had denied having any history of mental health treatment, inpatient hospitalizations, or receiving any medication for a mental illness in the community. He was described in the note as being alert. He was oriented to person, place, and time. He was well groomed. His speech was logical. It says that he presented with fair judgment and insight. He demonstrated the ability to advocate for himself when needed, and it was indicated that no mental health treatment was needed. So that was the evidence I kind of took when making my opinion about him being competent.
After your observations of Mr. Johnson, as well as the records from the Wayne County Jail at that time, was there any additional information you consulted before making your first report on competency in this case?
No, just the records from Wayne County Jail.
Okay. What was your initial report or finding on competency in this case based on those records you've described?
My opinion was that he was competent to stand trial. Whenever I do these evaluations, if you look at the statute, a defendant to any kind of criminal charge is presumed to be competent to stand trial. So there's a high ceiling of if someone is going to meet the criteria to be incompetent. And based on his behavior, even if I wasn't necessarily suspicious of it, you want to corroborate that with records, especially recent records from where he's, being held at in the jail. And the jail records did not corroborate at all his behavior that he presented with me on July 28th of last year.
And when was that initial report on competency drafted, Dr. Rodriguez?
I completed it on August 22nd, 2022.
And I know this is a silly question, but would you recognize that first report on competency if I showed it to you on Zoom today?
Yes.
I have to do this the old-fashioned way. I don't actually have a digital copy of it, but Dr. Rodriguez, can you, oh, this isn't going to work.
I do have the report in front of me as well.
Do you? Okay.
I printed it out.
Okay. And just to be fair, is that a 5-page report that was signed by yourself?
That is correct.
Okay. Your Honor, I would move for the admission of what would be marked as People's Proposed Exhibit 1 into evidence, the August 22nd, 2022 competency report.
I have no objection to all 3 of the reports being admitted into evidence. And if the court wishes to look at all of the medical records, we can certainly send them over also.
Thank you, Thank you, Ms. Silver.
Thank you.
And Your Honor, I don't know that we did that for Dr. Abramsky, but I would have no objection to those reports coming in as well.
Court will admit all 3 reports.
Thank you, Judge. Dr. Rodriguez, after authoring your initial report back on August 22nd, 2022, what was the next step you took in evaluating competency in this case?
So after that, I had completed a criminal responsibility evaluation, and I had met with him for 2 additional interviews on December 21st, 2022 and February 2nd, 2023. Keep in mind that I wasn't trying to ask questions pertaining to, you know, what is your understanding of courtroom personnel or things like that, because that wasn't part of the evaluation itself. However, I did ask him questions pertaining to his claimed auditory hallucinations that he had discussed in that report. When I completed the addendum, and when I also spoke with him, he was a lot more forthcoming. He was able to answer questions regarding his background information, and also his current adjustment at the jail, how he was doing, what kind, you know, his sleep, appetite, whether he was receiving medication in the jail. So I also took that into consideration. And he also was more forthcoming about hospitals that he had been hospitalized at or outpatient mental health treatment. And so he gave me a list of those, which I requested the records for. And once I received those records, I incorporated that into my addendum for my first report, as well as consulting with mental health staff at the jail, including the psychiatrist who had worked with him, and then nursing staff, and as well as consulting with a medical personnel at the Team Wellness Center. So I incorporated all of that into my addendum.
What was Mr. Johnson's demeanor like in your 2 criminal responsibility evaluations when you spoke to him?
Let me pull it up real quick. His demeanor was very different. He was superficially cooperative. And what I mean by that is it appeared he was trying to be very cooperative, but the way he was providing information seemed highly selective. He would give me a lot of I don't know answers, for example, or he would just try to focus in on things that I felt he thought was important to discussing whether he was innocent for certain things or whether he was aware of certain things that he had done when we were going over the criminal responsibility in his narrative. That said, let me see. His outward expression of mood, he was euthymic. He wasn't either depressed or his mood wasn't elated. He described his mood as happy. His energy level was fine. It was adequate. He was alert. He was oriented. He knew where he was and the approximate date. He was able to give his birth date this time. His thought process overall appeared just organized and intact. His speech was normal. He did give long pauses when I was asking questions pertaining to his charges. And again, it seemed like the information he wanted to give me was highly selective and quite guarded in that respect, but very different from his presentation from when I had first evaluated him in July of 2022.
During this second and third times that you spoke to Mr. Johnson, did he make any further mention about the hallucinations or the things he had been hearing at that time?
Yes. So the first time when I met with him in July 28th in 2022, it appeared to be more delusional in nature, right? He was saying he was an archangel. He was supposed to be in heaven, all these things. He didn't mention that so much or at all, actually, during my meeting with him for criminal responsibility. He focused more on auditory hallucinations. So he had claimed that he had been hearing these auditory hallucinations since he was a young child. He described them as sounding like aliens, that the sound effects was like the clicking of a mouse, like a computer mouse. He says that That was their language. It was the clicking of a mouse, that they speak to him and he understands them. And he says that they have gotten progressively worse as an adult, which is very atypical. When he was telling me this, usually when people are hearing auditory hallucinations, they are male or female voices. They're speaking in English or the native tongue that the person understands. I've never heard anyone in my however many years of working as a psychologist, anyone describe hearing voices in this way. And then there was also, I thought was interesting, is when I was asking him questions, like, is there anything that helps lessen the voices? And he would just say, I don't know. Like, he was very vague in answering those questions. And typically people will say, well, I'll watch TV, or I'll listen to music with headphones, or if I'm around people, it lessens them. And he didn't give me any of those answers for that.
Did you make any further observations during the course of the second and third conversation with Mr. Johnson as part of this evaluation?
Just looking at what I wrote, in fact, I don't think he even mentioned the archangel, the claim of being an archangel like last time. This time the second two times afterwards, he was just really focused on, hearing voices. And again, the fact that he said he had been hearing them since a child and it had worsened as an adult, when reviewing the records, he had never claimed to hear aliens or voices at all, nor were these claimed auditory hallucinations ever observed by mental health staff. In fact, what I wrote in my addendum report is that the first time he had ever claimed to be hearing voices, which was self-report at the jail, wasn't until October of last year. And this was, almost 3 months after I had evaluated him for competency, which I thought was highly suspect.
Why is that something that you're suspicious of, the initial or the first time these auditory hallucinations, as you call them, not occurring until October of last year?
Well, he didn't. When you look at the Wayne County Jail, and I did the updated Wayne County Jail and the criminal responsibility and the addendum report, there is nothing until he was claiming, hold on. It wasn't until October 4th. That was his first report of audio or visual hallucinations ever in the lifetime of records that I reviewed. He had never, while he did have diagnoses of bipolar disorder, which is a mood disorder, what he was displaying and reporting to me during the 3 occasions that I had met with him were experiencing delusions and auditory, visual hallucinations. None of that was in the records up until October 4th of 2022 at the Wayne County Jail, and this was by self-report. I had also spoken with the psychiatrist and other mental health providers that had worked with Mr. Johnson, and the psychiatrist said, he had never heard him speak about being an archangel, and that initially there was concerns that he was acting bizarrely, or he was self-reporting that he was hearing voices. But he said by the time that he had completed a psychiatric evaluation with him, his own quote was, none of that existed. And he did prescribe him Zyprexa, which is an antipsychotic medication, but the psychiatrist said that he prescribed that for, I believe it was anxiety only. It was not because he was experiencing hallucinations or of any sort. So again, just looking at the records, in Mr. Johnson's report of these things were not corroborated at all when you're looking, from when he was initially diagnosed with ADHD as a child. In fact, I don't think he was diagnosed with bipolar disorder until when at Core Psych PLLC, and that was in 2021. Which, based on based on the report in those, it does very much seem like he would meet criteria for that. But the psychosis that he appeared to report to me or present as was not corroborated in any recent records.
Based on your review of, you kind of anticipate a lot of my next questions with your answer just now, Dr. Rodriguez, but was there any further support based on the records that you have been able to review as part of your competency evaluation in this case that would support a diagnosis of some sort of psychosis for Mr. Johnson, based on both his self-reporting, but also his records that you have available to you now?
Besides the Wayne County Jail records from October, which was due to his own self-report, I don't believe there was ever any observation of these archangel delusions or these auditory hallucinations of aliens. None of this was supported by the mental health professionals I spoke with and nursing at the Wayne County Jail. So no, I would say that that was not supported. And even when looking at, again, all the other hospitalizations or outpatient mental health treatment, he consistently denied any existence of auditory or visual hallucinations. And they were not observed by the mental health staff at those agencies.
Now, Dr. Rodriguez, you've been present for the entire duration of this competency hearing, is that correct?
Yes, correct.
As part of your evaluation, did you at any point do any IQ testing or testing along those lines?
No, I did not.
Is there a particular reason why, as part of your competency evaluations, you don't do any tests along those lines?
Typically, if I feel there's cognitive testing warranted, it's usually if someone has been diagnosed with an intellectual disability, also known as mental retardation. And oftentimes people with an intellectual disability, they try to fake good. They try to fake smarter. And so when we give those cognitive tests, we want to make sure, are they truly understanding or are they just giving their best guess? So that's typically when we do cognitive testing. In the case of Mr. Johnson, there wasn't, even if I wanted to do cognitive testing, the way he presented in July 28th, 2022, when I initially attempted to complete the forensic evaluation, it was only 15 minutes and he wasn't responsive to most of my questions. He interrupted me and eventually refused to answer questions, which ended up in the interview being ended at 15 minutes. So even if I wanted to, there was no possibility that I would have been able to at that time.
Based on your follow-up conversations in the second and third evaluation, did you have any concerns with regards to his to a potential intellectual disability at those times?
I did not.
So based on Dr. Rodriguez, all of the information you gathered, as well as your conversation with Mr. Johnson, the subsequent times, were you able to come to any sort of opinion with all that material as to the competency of Mr. Johnson?
Well, again, when I was evaluating him for criminal responsibility, my questions were focused primarily on how he was thinking or feeling at the time of the alleged conduct. So my focus again wasn't asking him, you know, what is the role of a defense attorney? Do you know what a guilty plea is? That said, the fact that he was able to answer my questions about his background history, his, you know, current functioning in the jail, he was able to give me his narrative of what, you know, what he said happened at the time of the crime. If someone is incompetent to stand trial, they're not able to give me that information. They're not able to kind of hold it together during the interview to even respond to those types of questions. So I did take that into account. And again, even when, you know, when reviewing the new hospital records and the updated jail records, my opinion did not change about his competency.
And lastly, Dr. Rodriguez, based on, and this might be repetitive, but do you have any concerns as a result of your evaluations of Mr. Johnson about his ability to assist or take meaningful part in a trial in this case?
Based on the information I have and the records and consulting with the staff at the jail, I would say I do not have any concerns. Just the way that he was able to give me relevant answers. He was able to, you know, sit still in the chair during the criminal responsibility evaluation. He was able to give me a narrative, things like that. Again, I didn't ask him the questions, the legal questions pertaining to that, because I had already evaluated him for competency. But just overall, with the information I have, I do not have any concerns.
Thank you, Dr. Rodriguez. Your Honor, I don't have further questions at this time.
Thank you very much. Ms. Silver, is this you? Comes it back to Ms. Cross?
It's me.
Okay. May proceed.
Thank you. So, so you told us that you reviewed the court orders and initially, and you contacted the attorney, which would be me, to discuss my concerns. Is that correct?
Correct.
Okay, and so when did you receive the assignment that you were to evaluate Mr. Johnson?
I likely received it we usually get it the Friday before the week that we're supposed to see him. So within a week, I received those court orders.
Okay, and so the court orders, of course, would have included names and contact information for the attorney as well. Is that correct?
That is correct.
And in reviewing your report dated August 22nd, 2022, it appears that you made contact with my office on July 28th of 2022, which is the same date that you met with Mr. Johnson. Is that correct?
Yes, I did meet with Mr. Johnson on July 28th, 2022.
So you called prior to your meeting with Mr. Johnson. Is that accurate?
Yes.
And I was unavailable at that time. Is that correct?
I checked on Avatar and it says that I left a voicemail, but I did not receive a voicemail back.
Okay, but that would have been the same day that you saw him. Is that right?
Yes.
All right. Now, you indicated that you were suspicious of Mr. Johnson's presentation, so you got the jail records that were available to you at that time. Is that right?
Yes, even if I'm
the
not
May through July records.
Yes, even if I'm not suspicious of someone's presentation, I always request records from the jail just to get a better understanding of their functioning and how
Okay,
they're
but
doing.
your response earlier was I was suspicious, so I got his jail records. That's why I asked the question in that manner.
Yeah.
Now, you indicated that that Mr. Johnson had denied at that time having ever had any mental health treatment. Is that correct?
That's what he had told the Jail stuff. Yes, that's what the records I had received.
Okay, and do you find that to be, sort of, I mean, sometimes people who have mental health issues don't want to be perceived as such. Would you agree with that statement?
Yes.
I mean, they don't want anybody to think that they're, crazy or nuts, right?
Depending on the defendant, yes.
Yeah, so they might deny that they've ever had issues or ever had the necessity to have any treatment. Is that correct?
That's correct.
Now, you told us that, one moment, please. You told us that the second time, well, strike that. The first time that you met with Mr. Johnson and he, for 15 minutes, you based your decision that he was competent, it seems like, based on his account of his symptoms. Is that right?
Yes, just his presentation, just the way that he was talking about how he was an archangel. Yeah.
And so you decided that because you didn't believe his symptoms, that he must be competent. Does that seem like a fair statement?
Not necessarily. My suspicion was that he was trying to exaggerate perhaps mental health symptoms that he did have. Again, I didn't have any background information to go on beyond that. So yes, it was a hypothesis in my head was perhaps he is malingering these symptoms, but I wanted to corroborate that with the jail records to be sure of that, because sometimes there are times where I don't, I am suspicious of how they present, and then I have the jail records that state, okay, this is consistent with how he presented with me. So I wanted to see if that was the case for him.
Do mentally ill people sometimes exaggerate symptoms?
Yeah.
It doesn't mean that they're lying or malingering, correct? It means they're exaggerating their symptoms. Is that right?
It would be considered partial malingering, but yes.
What test did you do the first time that you saw Mr. Johnson to assess competency?
I wasn't able to perform any testing with him because he refused to answer any questions after 15 minutes.
The second time that you saw Mr. Johnson, you've indicated to us that the visit was much better. Is that correct?
Yes, he was more forthcoming with information. Yes.
You said that he was more cooperative with you the second time. Is that right?
Superficially cooperative, but yes.
And you didn't do any tests that time either. Is that correct?
We don't typically do testing for criminal responsibility evaluations.
No, well, I thought you did a follow-up report. I mean, I'm looking at a report dated March 16th, 2023, which is your addendum competency to stand trial. So you did an addendum report. So you're saying that even though you did this addendum report and you had reason to go back and, reassess and look at some other things relating to Mr. Johnson, you didn't do any testing the second time?
No, the addendum report was, I didn't do an additional interview because I had already given my opinion. When
well,
we do,
that's not what your report says. Your report says new sources of information, and I'm taking this right out of your competency addendum. It says new sources of information, interviews with Mr. Johnson, lasting 1 hour and 5 minutes on December 21st. Isn't that what your report says?
yes, and that was just, I had taken a part of the criminal responsibility portion where I asked him more in-depth questions about the voices he heard, and that was what I extrapolated.
Okay, so you're saying that while you call this an addendum for competency to stand trial, that really isn't what it is.
No, it is an addendum. An addendum to a competency to stand trial is if there's new information that I didn't have at the time that I first evaluated him. And at the time that I had evaluated the first time, he did not make mention of ever being hospitalized or receiving outpatient treatment. The jail records that I received didn't give me any of that as well. So I didn't have that information until the criminal responsibility portion. And that's when I integrated the new record stating that he did have a mental illness and incorporated that into the addendum.
Well, new information also is that he was more cooperative with you. And also, at the time you saw him in December, he was on medication. Is that correct?
That's correct.
Okay. So nonetheless, you did not do any additional testing or any testing at all to determine whether or not to assess competency. Is that right?
That's correct. With an addendum report.
And you've answered the question. Thank you. As it relates to the malingering aspect of it, as we heard from Dr. Atara Abramsky, there are tests that you could have done to determine whether or not your suspicion of malingering was accurate. Is that right? The Tom test, is that correct?
Again, the subsequent interviews that I had with him were related to criminal responsibility only. I am only paid to do the competency responsibility evaluation one time. I'm not going to, once I render an opinion, I'm not going to be doing subsequent interviews. But now that, again, like I stated, because there was new additional records and because I had consulted with other staff members pertaining to the criminal responsibility portion, I did integrate that into an addendum report. An addendum report is something I do on my own. I'm not interviewing the defendant again. I'm not getting paid for that. So I was just incorporating the new records that I didn't have.
Okay. But you agree with me, like we said before, that your new source of information was also an interview with Mr. Johnson, as indicated in your report on page 1. Yes or no?
A partial interview, yes.
Thank you.
Quick question, I'm sorry. In your first encounter with Mr. Johnson, did you give him the Tom's test to see if he was malingering?
I'm sorry, are you asking me, Your Honor?
Yes, ma'am.
No, I wasn't. Again, the interview was only 15 minutes and was ended early because he refused to answer questions pertaining to his charges.
I'm sorry, go ahead, Ms. Sullivan.
So do you work for the CFP? Are you an employee of the CFP or are you an independent contractor?
I did work at the CFP from 2017 to 2019. And then I work for the CFP as a contract worker remotely.
So you do what, okay. So in other words, if it's not part of your independent contract with the CFP, I mean, you don't go back and say, hey, I think there's some more work to do here. I need some additional funding. You didn't do that.
That's typically not our procedures. Once we render an opinion of competency or incompetency, and if there's new information, we can incorporate that into an addendum report.
Thank
Typically,
you for that. You've already said all that. Thank you very much. You indicated that you had some, well, let me ask you something. Mental illness, it doesn't always stay constant in its presentation. In other words, sometimes symptoms flare up, sometimes they, ebb, sometimes they flow. Would you agree with that statement?
yes.
Okay. And would you agree with the statement that people, especially young people like Mr. Johnson, who are placed in a jail setting for the first time ever, may decompensate from the time they come into the jail? There may be a progression of symptoms flaring up while they're jailed. Would you agree with that?
Yes.
Now, you told us that you spoke to psychiatrists that had treated Mr. Johnson in the jail. Who did you speak to specifically?
I don't think I have his name specifically in here. It is in my notes though. I don't have it in my report specifically. Typically they don't like me to use their names, so I just put mental health staff. But he did
Okay,
identify
so-
himself as
so
a
you're-
psychiatrist.
You're basing information that you're using to assess Mr. Johnson on somebody who you spoke to at the jail. You don't know who it is, or you're not telling us who it is today. Is that right?
He was a psychiatrist, and yes, and I woke with a social worker who had transferred me to speak with him.
How often did this unnamed, unknown psychiatrist meet with Mr. Johnson during the course of the time Mr. Johnson was in jail?
I believe he said twice.
And for how long each time?
He did not indicate that. He did do a psych evaluation though, which can take up, I don't know, it depends on the defendant, how long those take.
Well, you did a psych evaluation that took 15 minutes. So how long did the psych evaluations that this doctor did take?
I did not complete a psych evaluation. I completed a competency evaluation.
You indicated that when you spoke with Mr. Johnson the second time, you told us that he was highly selective in providing information to you. Is that correct?
That's correct.
And of course, that could be a direct result of his illness. Is that right? Of his mental health illness. I mean, the paranoia aspect of it. Is that an accurate statement?
It could be, but that was not the impression I got.
You told us that when you met with him the second time, he talked to you about the archangel on that day. Is that right?
I don't actually believe he did. He might have made one statement during his account or his narrative of what happened at the time of the crime. I'm just looking at it now.
You just testified when you were talking to Mr. Kehoe that he didn't talk about the archangel that day.
Yeah, I don't believe he did. I don't see it in here.
And again, at that point in time, he was on some medication. Is that right?
That's correct.
Now, you said that he described the voices that he hears from time to time as like a clicking kind of a noise. Is that correct?
That's correct.
And you said that you had not heard that in all your years, and that would be a total of 5 years. Is that right?
No, I've been working in the mental health field since 2022.
Oh, okay. So
I'm sorry, not 2022. I'm sorry. Since 2006, we'll say.
Well, you worked as
not as a doctor, but I've had subsequent training and working with people with severe mental illness.
Right. So to be clear, you began working in your capacity in 2017. Is that correct?
That's correct.
And that's when you began working at the Center for Forensic Psychology. Is that correct?
That's correct.
And you've been licensed, I guess, since 2016. Is that right?
That's correct.
You told us that nobody in the jail ever reported observing him acting as if he's responding to internal stimuli. Is that correct?
That's correct.
How often are people, other than inmates that Mr. Johnson is housed with, how often are other people observing Mr. Johnson in his cell?
I'm not sure. There's deputies that interact with him. There's nursing that meets, I assume, daily for his medication, and then mental health staff occasionally. I couldn't give you an actual answer.
Well, when they meet with him daily for medication, they hand him his meds and move on, right?
Typically, unless he has some sort of concerns or questions, and then it might be longer.
Okay, so that's about a 30-second observation by the nursing staff. Was Mr. Johnson housed in a mental health floor? Do you know?
I think once he said that he was suicidal, they had him on a mental health unit for observation.
And for how long was that?
Let me look at the records. Let's see. That was on October 11th. I think it was just for a day. And then he was, let's see. No, from October 11th, his suicide watch was discontinued. And as of October 20th, 2022, he has been housed in general population.
So in general population, are you telling us that people are, that nurses and mental health staff are going and assessing him and making observations?
Typically.
Typically?
That's when I consulted with them. Yes, if there's any issue of suicidality, typically mental health staff or some sort of staff will observe him daily to make sure that he is not engaging in self-harmful behavior.
You told us that as of October, he was off suicide watch. Is that right?
As of October 20, yes, October 11th.
My question is, who's observing him after October 11th to determine whether or not he's responding to internal stimuli?
I couldn't answer that.
You only know about his mental health history because he himself reported that to you. Is that correct?
That's correct.
And his diagnosis, did you agree with that diagnosis?
The bipolar disorder, yes, based on what I had read in the records, yes.
And you know that he has had some pretty serious mental health symptoms that have displayed themselves, including in May, I think it was, of 2021, when he was at Garden City Hospital. Is that correct? I'm sorry, June of 2021 at Garden City Hospital. Is that correct?
I'm looking.
That he required restraints, multiple doses of sedation to keep him calm, that he was given Haldol for antipsychotic medication,
yes,
a sedative used to treat anxiety, and a number of other drugs. Is that correct?
Yes.
And that was maybe about a year or so before he found himself in the Wayne County Jail. Is that correct?
That's correct.
In your clinical experience, when somebody is stable, if somebody who's got some mental illness is stable and expresses, is it if somebody is feeling in their own head that at a given point in time that they're stable, is it possible that they may not disclose symptoms at that point in time?
That's possible. Depends on the person.
If somebody is malingering or faking, is it likely that they would report that medication is stabilizing them or is assisting them in some way? Or would they continue to malinger?
I'm sorry, can you repeat that question?
Yeah, in your clinical opinion, if somebody is malingering or a malingerer, like you've said Mr. Johnson is it likely that they would then report that medicine is helping?
Possibly.
One moment, please. I guess my question to you is, what's the purpose of malingering or faking if you turn around and report? I mean, I imagine that your point in all of this is that somebody who's malingering, like you allege Mr. Johnson is doing, he's faking for some benefit or some purpose, right?
That's correct.
So what would be the point then if he's malingering, if he's a faker, for then reporting that, hey, thanks for the meds, they're helping? I mean, what would be the point of that if everything you've told us is true and accurate?
I can't speculate on that. All I can say is when I met with him in July 28, 2022, his presentation was not corroborated by the records received.
Okay. Yes.
I think I've heard enough. I get the gist.
Okay, I'm done then. Thank you, Judge.
All right, thank you. Thank you, Dr. Rodriguez. Appreciate it. I want to get all of the reports, any other information that you guys would like to forward to me. I'd like to render my opinion. I can do it as early as tomorrow if you guys are available. When they better by the look of your face,
Judge, just to make sure we're on the same page, do you already have all the reports or do you need us to send them to you? I think you have them, but I want to make sure.
I want to make sure too, so I would like for you to send them to me again.
Your Honor, I can do that right after this unless Ms. Silver, Ms. Kraus want to handle it, but I can scan them all in. I'll scan all the reports from Dr. Rodriguez as well as Dr. Abramsky.
I appreciate it. Thank you.
I'll never turn down Mr. Kehoe's offer of a system.
Of course.
Any other information you guys would like for me to review as well, I will.
I have nothing else.
Yeah, so Judge, tomorrow is really bad for me. Could we do this on Monday morning? Would that work for you?
Yes.
Judge, I started a jury trial that's definitely going, and it's a lengthy trial, but could I send someone in my stead to get a ruling from the court?
Yeah.
Thank you, Judge.
Make sure they have the calendar just in case we have to schedule something.
Certainly, Judge.
All right. Thank you, guys. Appreciate it.
Thanks,
Thank you, Your Honor.
Bye.
Thank you.
All right.
Bye, Mr. Johnson. I'll be in touch.
Okay.
All right. We are back on the record on People versus Darnell Gary White Jr.
Briefly approach on this.
Okay. Come on.
Yes.
Yeah. Yeah, just bring it. So
Yeah. So.
All right, we are back on the record. Versus Darnell Gary White Jr. Mr. Johnson.
People have no further witnesses, Your Honor.
And Your Honor, defense has no witnesses.
All right. People.
Based on the evidence placed before court, I don't believe that people have a sufficient basis to ask them why to go over on this case.
And Judge, I respect the prosecutor for his position. We have no objection. We are moving for the dismissal on each and every count that Mr. White is charged with.
Court will dismiss this matter for insufficient evidence.
Thank you.
Thank you.
Thank you.
I need to dismiss the order.
Yes, yes, we're carrying on for the court. Yes, we're ready. I'm sorry, 233-055-54-94-91-0-91-0.
Monday.
Is it on your paperwork right there? Yes. Thank you.
Do I need to sign that, Mr. Thomas?
I think so. Oh, yeah, it's the VAR. Good day. Good afternoon. Thank you, Your Honor.
All right, thank you, guys. Have a good day.
Likewise.
All right, Your Honor, you need to stay. Have a good afternoon. Thank you so much.
Call them up with the paperwork. We're gonna call them up with the paperwork.
Second time.
Any evidence need to go back to them?
They don't get taken down.
Getting out your way.
Bring it 5 minutes. Okay, work. Okay. You good?
I need to copy that.
Oh,
Okay.
thank you.
All right, thank you, guys. Have a great day. Yes, sir.
One for me and 2 for them.
Right. I'm good. All right.
I think I made it.
Thanks a lot. Have a great day.
Something else. Thanks, you too. Man.
Right there, Watson. You all right, Cliff?
Yeah, how you?
I'm trying to make it. Judge King trying to kill me here. City on the telephone.
Some fresh air.
Yeah, I'm trying to get out of here. Dismissal. That's together. All right, guys, see you next week.
All right.